Good afternoon. I'd like to call the meeting of the Board of Adjustment to order. Hearings before the Board of Adjustment are quasi-judicial in nature. Decisions of the board are based on the record of these proceedings. To grant a variance requires a concurrent vote of 4/5 of the members of the board. To reverse or modify the determination of an administrative official requires a majority vote of the board. Evidence submitted to the board for review becomes part of the record. Appeals of board decisions are to Superior Court and are based on the record. Appeals must be filed within 30 days of the date of the filing of the board's order in the Planning Division. A hearing before the board is conducted in accordance with its rules of procedure. Those who want to testify in a case are sworn as witnesses. The chairperson recognizes those who want to testify or their attorneys for presentation of evidence during the hearing. To ensure that all testimony is properly recorded, please address the board, state your name and address, and speak clearly. We also have historic preservation. So appeal hearings from the Historic Preservation Commission are in nature of certiorari. The HPC conducted a quasi-judicial hearing and made the decision to either grant or deny an application for a certificate of appropriateness. The Board of Adjustment's review of the decision is based on a record of the proceedings from the HPC. There is no swearing in of witnesses in these cases because no new evidence is received by the board. The board reviews the record in the case following areas: to ensure that constitutional rights, including procedural due process, were protected; to ensure that the HPC did not exceed its statutory authority or authority granted to it by the city ordinance; to ensure that procedural rules were followed; to ensure that the HPC did not commit an error of law; to ensure that HPC's decision was supported by competent, material, and substantial evidence contained in the record; and to ensure that the HPC's decision was not arbitrary or capricious. A majority vote of the board is required to affirm or reverse the decision of the HPC or to remand the matter to HPC for further action. Appeals of the decision to the Board of Adjustment are to Superior Court in the nature of certiorari. Our first order of business is to approve some minutes. Do we have a motion for the August 15th minutes?
I'll make a motion for approval.
Do we have a second?
I'll second.
All in favor?
Aye.
Opposed? We have a few cases today for withdrawal and continuance. We'll go ahead and get those out of the way. Old business, item 1, 311 and 315 Eastwood Road. The city staff has requested this item to be dismissed. Do we have a motion for dismissal?
I'll make a motion for dismissal.
All in favor?
Aye.
Okay. Item 2, 6005 Oleander Drive, Unit B. Applicant is requested to withdraw this item. Do we have a motion?
I'll make a motion for withdrawal.
All in favor?
Aye.
Aye. Item 3, 4202 Peachtree Avenue and 1415, 1470 South 42nd Street. Applicant is requested to withdraw.
I'll second.
All in favor?
Aye.
Item 4, 4202 Peachtree Avenue. Applicant is requested to continue this item. Do we have a date on that? Is it going to be October 20?
October 20, yes.
Do we have a motion to consider item 4 to October 20? Do we have a second?
I'll second.
All in favor?
Aye.
Aye. 4202 Peachtree Avenue has been continued to 10/20. Item 6, 2201 Sterling Place. The applicant has requested a continuance to October 20. We have a motion.
I'll make a motion to approve the continuance to October 20th.
Second. All in favor?
Aye.
Item 8, 938, 1121, and 1125 Montclair Drive. The applicant has requested a continuance to October 20. Do we have a motion?
I'll make a motion for approval of continuance to the October 20th meeting.
We have a second. All in favor?
Aye.
Aye. And then the last, nope, that's it. All right. 13 is, well, 13 is contingent
sorry.
on 12. So you're not chairman this month.
Continue the rest of them.
Yeah. All right, the first item before us is item 57527 Masonboro Sound Road.
Good afternoon. I'm going to ask anyone who's going to wish to speak, staff, applicants, and members of the public to stand up and raise your right hand. Do you swear that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Perfect. And if you haven't signed in, please do so. Thank you.
This item is for two variances. One is to the amount of fill allowed in a coastal high hazard floodplain, and the other is to allow fill within a conservation resource setback area. The property is zoned R20 and contains approximately 8 acres. It is bounded on all sides by residential and the intercoastal waterway. This property is located in a flood zone. It's Special Flood Hazard Area AE 12 and Coastal A Zone 13, which is the coastal high hazard area. On March 2nd, 2021, city staff received a complaint that fill had been added to this site in excess of what was allowed in the coastal high hazard zone. Following a site visit confirming the validity of that complaint, the city issued a notice of violation on April 27th, 2021 for the placement of that fill and the placement of fill in a conservation resource area. Within conservation resource areas, no fill is allowed at all within 37.5 feet of the conservation resource buffer, and that's pursuant to Land Development Code Section 18287. There is a survey that the applicant has submitted that shows the floodplains, and it's hard to see here, but there are some points that show the amount of fill, the change from the pre-fill elevation to the post-fill elevation on this map. And what you would see looking at that, if it's clearer on your screen or in the attachments, is that the amount of fill added is variable between, less than a foot up to 3.5 feet in some places. The applicant is present today to answer some questions and give a presentation themselves. Staff would ask of the applicant as part of the presentation that they specify what the amount of the encroachment into the conservation resource area is. I would like to point out that there are two separate standards for the separate variances. The floodplain variance will have the 11 findings of fact that have to be met for floodplain variances, and then the variance to fill in the conservation resource area needs to meet the traditional hardship for findings of fact set forth in City Code and North Carolina General Statute. So with that, I'm happy to answer any questions you may have of staff, and the applicant is here to provide additional information on the request.
Any questions for staff at this time? Thank you.
Thank you.
Thank you, and good afternoon, Mr. Chairman, members of the board. My name is Matt Nichols. I'm here today representing the applicant and property owner, Oak Forest Properties, LLC. With me here today are Peggy Bedore, who's the owner representative, Howard Resnick, civil engineer with CSD Engineering, and Greg Finch with Land Management Davie. And we hope to be able to answer any questions you have and explain the request. We did have a presentation which I think will be helpful in showing the conditions of the property and the nature of the request. So before I got into the specific variance requested, I thought it would be important to just show the board the property itself, which is really a very unique, remarkable property in New Hanover County. This is on Mason Bore Sound Road, and you may not really notice the house because it's set sort of so far back off of the road, and with the tremendous live oak trees on the property, I can't say that I ever really knew the house was there until I got involved in this. But this is an image from Google Maps, and you can see Mason Bore Sound Road there on the left side of the screen. The property is quite remarkable, and we have some information from the National Register of Historic Places if the board is interested. But just to note a few things, that it was designed by Henry Bacon, who I learned was a Wilmington native, and also designed the Lincoln Memorial. According to the information that we found, Mr. Bacon was commissioned and at the time was then engaged in the design and construction of the Lincoln Memorial. And the pictures don't really do it justice as far as the trees and the architecture and the property itself. So I just thought I would walk through those, just emphasizing that my client has, I think, done a great job of maintaining the property and has been restoring it. It's a very big property to maintain, and that's really the overall goal of what she is trying to do and continuing to try to do with the property. So if I may just run through a few of these photos. Before I get to that, it's noted in the New Hanover County Historic Architecture book, and the property, I understand, the name of it is Live Oaks, and I think that's aptly named when you see the photos. As I mentioned, that was designed by Henry Bacon, and I'm sorry, go back. And the one thing, just reading through the report, the one thing I noted that even in the report, it noted that the immense lawn with unobstructed trees is in the back of the property. You'll see how it slopes down to the waterway. And so we have some older photos, and you'll see that we don't really think anything has changed, as you'll see from these older photos. And my client's trying to maintain that, that historic lawn. So this was a photo we got from the archives, and I think on the back of it was dated 1984. You can see just the historic photo. And then here's another one, and when you see the more current photos that we took, roughly a week ago or so, you'll see that same grape arbor, and it looks largely the same. So here's the front view of the property. I definitely don't know the architectural terminology, so I'm just going to go through these, but I'm glad to stop on any of them in particular. You'll note that the live oak trees there are really incredible. It's almost like Airlie Gardens. And I took a photo of this just to see. It's hard to tell from sort of further back from the house, but it's what I understand this is a coquina, which is just tons and tons of seashells, I think pressed into the concrete or whatever material that is. It's hard to tell when you're back from the property, but up close you can see it's really incredible. This would be the sort of looking back out through the entryway, one of the entryways. And then here's a side view of the house. Just another view of sort of the side and the back of the house. This is looking more to the south. You can see the lawn as you can even tell there that the property slopes down significantly. Here's a back view of the house. That's looking more to the north. In the distance, you can see the neighboring property, but you can tell from that photo how it slopes down significantly to the water. This is sort of similar to the 1984 photo that we showed with the grape arbors. And again, looking back down toward the water. Here's down near the water, looking back up toward the house. It's back up in the parking area, looking back toward the water. Just by point of reference, you can see the adjacent property to the south there, and just in my non-expert looking at it, it looks roughly the same or similar to the properties on both sides. There's the property to the north. Just some other vantage points here. And so what I would emphasize too in this request, it doesn't involve any structures. It's not to put any buildings or structures in the flood zone. This is purely about fill that was placed there for the purpose of maintaining the property. And so I know the staff packet is pretty extensive in this matter, and it was looked at by the Corps of Engineers, and I have this email to hand out, and I've got Greg Finch here, who the email is addressed to. This is an email from Brad Shaver, who is project manager with the U.S. Corps of Engineers, and you will see that it's an email response to Greg. I understand they met on the site. I'll let Greg elaborate if the board has questions about the site meeting that they had with the Corps of Engineers and with the Division of Coastal Management to look at the issues. And from what I understand, that the email states that based on several soil bores yesterday, again, it's dated April 2022, it was determined that the most recent fill, which prompted the inquiry, did not occur in 404 wetlands. So there was not a wetlands issue, and it appeared that the original wetland elevation was filled years, if not decades ago, by others. And then Mr. Shaver had an attachment to that email. I think that's the next slide. But the conclusion is that the Corps is taking no action on this property and is closing out the unauthorized site investigation. So my understanding is that the issues were resolved with the Corps. And then, yeah, here's just a highlight of that same email. And then here's the attachment to that email. I don't know if the board has that, but I would like to could maybe hand that out. We've got copies of it. My paralegal, Nikki, will maybe hand it to Ms. Thurston, and I'll keep moving through the slides here. And then secondly, with regard to the Division of Coastal Management, they also understand we're involved in those meetings, and I'll let Greg answer any questions about that. But that too has been resolved. It resulted in a $532 fine or penalty, and that has been resolved. And my understanding is that the state is considering the matter fully and completely closed. So the last item on sort of the list of things that brought this to the forefront was the city's inquiry into the matter, and the city did issue notices of violation. My client is here requesting the variance. We hope to resolve the issue as it's been resolved with the Corps in the state. So in light of that, in anticipation of the hearing, we had Howard Resnick, who's here. I'll ask Howard to come up, please. Civil engineer, to do a fill or flood analysis. And I have copies of that report for the board. And I'll ask Howard if he can. Howard, do you mind coming up and just explaining what you looked at and your the data and the conclusions that you've reached with regard to the impacts of the fill and the flood plain?
Sure. Howard Resnick with CSD Engineering. I was asked to prepare a report analyzing sort of a before and after condition with respect to the placement of the fill on the subject property. And so the approach we took to this was, first of all, we were fortunate to have existing data prior to the placement of the fill. So we took that data, we analyzed it digitally, create a surface, then create a second surface, which was based on after the fill was placed on site. Comparing the two surfaces gave us a volume. That volume is listed on the report. I put proposed volume. That's actually the volume of the fill which was placed on site. We also, because of just the grand scale of these floodplains, we had to limit the scope of our report. So we just took if you can see at the exhibit, I'm not sure if it's one of the slides, the last page of the report, we had to sort of limit our scope of the report. So we took sort of somewhat of an arbitrary limit in terms of area that we used within the floodplain for analysis. And we utilized LIDAR data, which is topographic data that's taken from an airplane. Basically, they shoot laser and record time. Long story short, they get an overall topography. That data is available either within the NC flood mapping online program, or even the county has LIDAR data. So we utilize LIDAR topographic data, and we're able to come up with a total volume of water from base elevation up to base flood elevation for both AE elevation 12 and AE 13. With that volume, we then compared our fill volume to that total volume to demonstrate the percentage or how large of an impact it would make on that fill volume on the overall flood volume. And then we presented the results both in terms of percentage for both the AE elevation 12 and AE elevation 13 floodplains. But we also then converted it using the area and converted it to inches or an actual height of impact within that report scope area. And it was, you know, it's something like, I don't have the information in front of me right now, but it was in the hundredths of an inch. I think it was something like just over 600ths of an inch. So a very, very small impact. And in general, you know, that degree of impact is negligible. Do you guys have any questions about the report, the methodology, or the results?
Any questions?
I just had a question. So the city's coming up with it, it's more than 2 feet of increase in the amount of soil that was put in there, the height. Where does that come from if we're only talking about inches, like less than 1 inch? Where do we come up with the 2-foot variance?
So I'm not sure I know exactly the height of the fill that was placed on site. Again, I don't think that'd be one unit. I don't think that'd be one measurement. I think there might be an average amount of height. But again, what we looked at, we compared the surfaces, so it gave us a volume of the fill, which was the 176,000 cubic feet that's listed on the report. So again, we looked at the volume of the fill, compared it to the volume of the two floodplains, elevation 12 and 13, and then converted that to a percentage of impact and then a height of impact.
Right, I'm just trying to understand, you know, the requirement is a height requirement, and the city's coming up with it. There's more than 2 feet there, and I don't know where the discrepancy is coming from.
I don't know if there is a discrepancy. Catherine, can you speak to the height requirement from the city's standpoint?
Well, within the coastal high hazard area, there is that limitation of 2 feet of fill, and I'm in figuring out what the difference was. I was looking at page 24 of your case summary, which, by the way, I would like to take this opportunity to admit the entire case summary and the attachments into the record. I believe I failed to do that earlier. But you can look at the different points that are on there.
Do you have something that you can put on the screen that you blow it up?
I
'Cause it's pretty
can put it
tiny,
on the screen.
Very hard to read.
Yep. It'll still be hard to read, but I'll do my best
Can
here.
you increase the area that we're talking about in size so that we can actually see?
Can you see those points? And if you turn to page 24 of your packet, it'll be a little bit clearer. Oh, thank you. Aha. So there is a magnifying glass where we can blow it up, but then the numbers get very fuzzy.
Yeah, if you could blow it up maybe a little bit more, just that area that we're talking about.
I think that might be the extent of what we can do with my technological expertise. But for example, if you look at the one that is closest to Mason-Burr Sound, you'll see the original grade at 3.7 feet. And then whenever it was evaluated on May 20th of 2021, you'll see that it's 4.4 feet there. So it's less than a foot of fill in that area. But not having the actual conservation resource on this survey, it's hard to tell where the extent of the fill in excess of 2 feet, or well, there was no fill within the 37.5 feet that was allowed. So that's why we need that line established, but then also within the coastal high hazard area, which is on that map, several of those points exceed 2 feet. And I'm just looking at, for example, This one right here that I'm pointing to on the screen shows a difference that goes from 9.37 pre-fill grade to 12 feet. So that's in excess of 2 feet. Does that make sense?
So who did this? Who
it's a-
did this? Did the city do this measurement, or was this something they had surveyed?
Rob Gosley, a land surveyor. And actually, it looks like it may have been Bob Jones out of Rob Gosley's office. That is an exhibit that was submitted by the applicant.
My understanding is the Corps of Engineers has signed off on this, and the applicant paid a fine to DEQ to close the case with them. Is that right?
No answer. Did she
No,
answer
he
your
said
question?
yes.
Oh.
We don't have that information. I don't know if that's something that the applicant has or not.
I'll clarify, in my non-expert looking at photos, it looks similar, but I'm in no way saying there's identical between any of the properties. I'm not qualified to say that.
Well, I walked the properties, and it's fairly level across the three, the subjects on both sides. They were actually filming a movie there, I think, when I went out there. So.
I believe they were filming a movie out there in the recent history. And I want to clarify, too, I certainly don't speak for the Corps of Engineers when they sign off on things. All I can do is just indicate to you what the email said, which, and I can have Greg explain that, but the Corps is not taking any action and is closing out the unauthorized site investigation. So I understand that to be resolved.
What was the main purpose of adding the fill to begin with?
It was really to sort of, I'm not going to say stabilize in the sense that the water was the soil was falling into the water, but my understanding was to reestablish the lawn. It was lower than the property to the north, I believe. And it was to get the fill in there, get the lawn back established, which I think they've done a great job of reestablishing the grass and maintaining it. But it was not for the purpose of, again, no purpose of adding any structures, or not going to add an addition to the house or anything like that. It was really just maintain, hopefully continue to preserve the historic property, beautify the property. I know that my client, who is here and can answer questions if you have more specific questions, but it just feels bad that did not get a permit or talk in advance with the state. So it's really trying to address the situation that arose, and looking at it, the variance would sort of close out the three jurisdictions that have looked at this with the Corps, the state, and now the city. So this is the last, also very important step of trying to make things right with the city. Again, there was certainly no ill intent or,
And just to confirm what Scott was asking, there wasn't a study done on the adjacent properties on how those would be impacted?
Excuse me, can you guys speak into your mic, please?
Sorry.
Thank you.
Was there a study done that how this fill would impact the adjacent properties?
I think that's what Howard had looked at.
That's what my study was
You mind-
that's what my study was intended to do,
Okay.
was demonstrate very little, if any, impact at all on adjacent properties. And that's why the scope of our study covered, it was a pretty great distance. I think we covered like from Whiskey Creek to the next creek to the north. So, but again, you know, the purpose of my report was to quantify that fill in relation to the available floodplain capacity in that general area. And obviously, you know, we couldn't extend that across the Atlantic Ocean, so we had to limit it. So we went from like the waterway, you know, Whiskey Creek and north to the next creek, Hewlett's Creek, and that's where we ended our study. But obviously, if you figure out the entire available floodplain, it is exponentially greater.
It seems like the most immediate concern would be the adjacent properties, and if, you know, this fill has created any kind of runoff towards the adjacent properties. Is there some kind of a swale between these properties on either side of these properties, or is everything slope in one direction? Does it get lower as it goes south or north, or is there anything to mitigate the increase in height here at the property lines? Is there any kind of swale or anything to prevent it from running off onto the adjacent property?
I thought I'm going to check with my client, but I thought there might be a swale between the property and then the property to the north, if I could go back to that photo. Yeah, Peggy, come on up.
Just in general, I am familiar with the area. I live really close to there and pass it all the time on the boat. That entire property just sloped straight down towards the waterway. You know, I'd be surprised if there was much, if anything significant sloping towards the direction north or south towards either neighbor. So again, that's just me from being familiar with the property.
This is Peggy Bedore.
Hello, I'm Peggy Bedore. So the main reason that we put the fill in is because there are 4 properties that line the waterway. There's ours, and then 1 to our left and 2 to our right. The farthest one over here and the one to our left, they had been maintaining their properties, and they were significantly higher than ours. Our property had experienced significant neglect for probably 50 years or more. No one was taking care of it. You know, the Parsleys owned it. They lived in it as a home. The second, third generation of Parsleys, they really didn't have much money, so they didn't do anything to the property. So really, we did this to keep from his property putting water onto ours, because that's basically what it was doing. From both sides, they were higher than us, so they were sloping towards our property. So when we put the dirt down, Dr. Godarzi to our left, he put in a big ditch. I'm sure I'm not using the right terminology, but he put in a big ditch so that neither of us would slope on the other. The Kings directly next to us, we actually offered, they do not claim they don't have the financial means to do that. So we actually offered to help them with their property, but they didn't want that. And then Mr. Johnson on the other side, his now still slopes onto the Kings, but they haven't done anything about it. So.
Peggy, and if I'm not mistaken, you bought the property from Dr. Godarzi.
I did,
Right, yes.
yeah.
So Dr. Godarzi owned, yeah. I just wanted to clarify, Peggy, if you could explain, my understanding is you bought your property from Dr. Godarzi, who is the owner, still the owner of the property shown in this photo as adjacent property to the north.
That's correct.
Yeah.
That's correct. And, you know, when they so we had already put the dirt down when they came to measure. And I'm sorry we didn't get a permit. We've never done anything like this, so we didn't know what we were supposed to do. And so when they came, we immediately hired Bob Jones to come out, and he did the elevation survey. It was difficult to get an exact level. As a matter of fact, he told us later that where he had measured from, and it was actually lower than where he should have measured from. but there's no way we could have gone back and taken all the dirt up. Another thing is, it was very fresh, so even now you can visibly see that it's gone down from where it was when we first laid it down. So even those few inches, that's a discrepancy on the elevation survey are probably lower even now. But I'm happy to answer any questions.
Just so you're all aware, some of this came in from a site visit based on a completely separate complaint, and then a zoning officer went out to the site and realized that fill had been placed on the lot as well. We did get some complaints from the neighbors. I do not know which ones actually complained about the fill being placed to. I did not take the calls, and a lot of times we aren't, whenever someone calls to make a complaint like that, we don't necessarily require that they provide their name, and a lot of times they don't.
Like I stated before, I did a site visit and walked the property, and there doesn't appear, the subject property has not been built up above the properties on either side. And there does appear to be a slight swale, as you can see in the photo there on that side. The other side is where the grape arbor was, and I didn't really walk behind the grape arbor to look back there. So.
If I may, just take a moment, I was going to just now, but my mic was a bit louder than I wanted it to be, but if you all could make an effort to speak into the microphone so that Casey is able to get a good recording on this meeting, that would be very much appreciated. Oh, and also make sure your mics are on. There should be a little green light if it's on.
Mr. Chairman, I think we just had a few more slides, but they were really
Okay.
just to go through the criteria.
Sure.
If the board would like us to do that, and also continue to answer any questions. I'll just fast forward and make this brief. I think we've gone through these. The floodplain criteria, I would respectfully contend that we certainly would meet all those criteria. Like I said, we're not asking to put anything in the flood zone that would create a hazard as far as a propane tank or a structure that could create danger to other properties. So this is somewhat of a unique request. I think based upon Mr. Resnick's report, again, I would say it was fair to say that it's, in his expert opinion, it's not going to create a hazard for the other properties. I think the property itself is very significant, and I do think there's some just value in preserving the property. It is a very unique location and history. And then all these, we can address any of these if the board had any particular concern, but it doesn't create any safety access as far as if there was an event, health, welfare, safety to other residents and things. And then as far as the conservation resource regulation variance, which is a part of this too, we would contend that we meet the criteria, the 4 general criteria, which the board's very familiar with regard to the variance. I think it would be a significant hardship, unnecessary hardship, to go in and take out what is there. That would be difficult to do. I'm certainly not an expert and can't give an opinion on what impact that would have, but I think that would probably have an adverse impact. It would be disruptive. And I just don't think that serves really any beneficial purpose to go and take out what was put in. The Corps has closed its file on this. DCM has apparently closed its file on this. And we're not asking to do anything from this board that's not out there now. It's really just to hopefully put a resolution on this. And we appreciate your consideration. We're glad to answer any questions you might have.
Thank you.
Thank you.
Any further questions for the applicant?
No, I'd just like to commend the applicant for taking on that that property. It's certainly a significant historical property and beautiful. I mean, just amazes me that structure.
Thank you so much. I really do appreciate it. I grew up in Wilmington. I love Mason Sound. I fell in love with it when I was a child, and I always wanted to live over there. And when this property came available, I felt so blessed to be able to do that. And we've just been pouring our heart into it because we love it so much, and it's just a special place. So thank you so much.
Yeah, it's got to be a joy to be able to live there. I would have loved to have lived there too, but my pockets aren't that deep.
Well, we're actually not living there right now, but
Okay,
there's the
well,
whole
eventually,
story
hopefully you will.
behind that. But
Yeah, no, it's beautiful.
well, come visit anytime.
Okay, thanks.
Thank you. I'm going to open up for public comment. Is there anyone here to speak in favor of or opposed to the requested variance? And I will close the public comment and open it up for board discussion.
Catherine, does the city have any concerns about any potential issues with the increase? I mean, runoff to the sides of these other properties. Was there anything that came up when you investigated the site that looked like it was going to be a real issue?
Well, I believe that the point of having the restrictions on fill in the coastal high hazard areas is in recognition of the potential impacts on other properties whenever that fill is placed there. We didn't have any engineers go out onto the site to look for specific issues out there. So no, the city does not really take a position of the potential for damage based on the fill that was placed on the site. I would like to, if the applicant didn't already, ask that we enter all of the exhibits that they presented at the hearing into the record as well.
Thanks.
Thank you.
Yeah, I'll just say that, Catherine, the map you just did the math on helps a lot. I mean, the max elevation it went up is just over 3 feet, and that was a year ago, so it's probably settled some by then. Additionally, it doesn't even seem to really matter with the neighbors because the Godarzes apparently dug that ditch. There's a ditch going down the side, so it's almost irrelevant whether, I'm surprised they were even able to do that back when they did that.
Well,
So-
and, engineering study was done, and the Corps of Engineers has closed their case on it, and the DEQ has closed their case on it, and a fine was paid for no permitting. So I think everything that could have been done post-fill has been done. So.
Just for the applicants, clarification, what Mr. Monroe was talking about is while you were up there presenting, I did the math between the elevation points pre-post so that they could just look at that number instead of the 2 elevations that were taken on different dates and, yeah, do that math.
Any further discussion among the board?
I mean, it was definitely not done with any malice, but we do have permits that we have to apply for, and a lot of times that process wasn't approached the right way. But like I said, I don't see damage there, but there is a process and a procedure that we should be enforcing in these matters.
Well, I agree. And, the Corps of Engineers and DEQ did sign off on it. Of course, DEQ required a fine to be paid, but it's been paid. So I think everyone acknowledges, that, including the applicant, that permitting should have been put in place prior to, but I do think everything's been done post-fill to meet any requirements and mitigate any damage.
Does the applicant still owe the city for all the fines, and are we voting today that wipes out those fines?
They appealed the notice of violation prior to the issuance of any citations. Is that correct? Well, I believe.
Because I read one for 3,600, one for 200, and one for 100.
Yeah, no citations were issued for this property by the city.
anyone like to propose a motion before the board?
I'd like to make a motion to approve the two variances. One is a variance to the maximum allowed 2 feet allowance for fill in a coastal high hazard floodplain, and then the variance to allow fill within a conservation resource area based on meeting the 4 findings of fact.
We have a motion to approve the variances as requested.
I'll second.
We have a second. All in favor?
Aye.
Opposed? Motion carries. Thank you. Believe it or not, we finished 7 of our 15 cases.
Awesome.
The next item before the board is 201 Chestnut Street, also known as Project Grace, which is the northwest corner of North 3rd Street and Chestnut Street, and Board Member Hovis needs to recuse himself from the hearing of this, so we're going to bring in our alternate board member. This is item 7. The first 6 went by so fast. Thank you.
Thank you, Chairman Moore. This is 216, 218, and 230 North 2nd Street, and 216 and 228 Grace Street, which is better known as Project Grace. It's the redevelopment of the existing downtown library site. And the request before you today is to the city's requirement that all off-street loading is done in a forward motion. The applicant submitted a variance to that requirement on July 6th of 2022 based on their need to allow backing into a covered facility for the loading and unloading of delicate library materials. We're also going to move the museum to that site, and so there will be some irreplaceable historical artifacts that are moved into and out of the museum and the library. So for that reason, the applicant has requested a variance to Land Development Code Section 18346 to allow their vehicles to move into that covered dock. This is the site that's in question. You can see that it's beside the county's parking deck, directly adjacent to it. It's zoned CBD. This is the site plan. I'm sure that if you're trying to read any of the text that's on that site plan, you're going to really struggle on that, but it is included as an attachment with your packet. And this variance request will be subject to the 4 findings that are shown on the screen above. I'm happy to answer any questions you may have of city staff, and the applicant is also here to discuss the proposal.
Any questions for staff? Thank you.
Thank you.
Good afternoon. My name is Amy Schaefer. I'm here. I'm an attorney with Lee Case representing the applicant. I'm here with Rob Balland from Paramount Engineering and Charles Boney of LS3P. I am not an engineer, so I am not going to speak to you very much. I'm just here for some technical issues. So I would like to ask that the staff report and application be entered into the record as evidence and accepted as such. And I would ask Mr. Balland to come up, explain his credentials, and then he can start getting into the meat of the matter of what we're here for today.
Hi, good afternoon, Mr. Chair, board members. As Amy mentioned, my name is Rob Balland. I'm a professional engineer with Paramount Engineering. I've been a professional engineer for 29 years here in Wilmington, the entirety. This project is very unique. I'll start with that. You know, we have a project that's downtown. I think all downtown projects are relatively unique because, you know, there's no really consistency down there. There's a lot of different structures, different redevelopment projects, and what we're trying to accomplish here. In this case, we're dealing with a library and we're dealing with a museum, New Hanover counties. They each require their own set of, criteria for what their needs are, specifically for loading and unloading. I'll start with the museum. The museum's got exhibits that come in. They're part of, a program where they can show different exhibits. They come on display for maybe a few months, and then they leave for, and then another one will come in. So, they change out. They're telling me, maybe every 2-3 months they change out exhibits. So this isn't a frequently done daily, type of delivery, but it's one that's needed. It's needed for multiple reasons. It needs covered entrance so that it's protected from weather, but it also needs to be protected because it's usually valuable information, and we don't, want it out there in just plain sight for anybody to come by and disturb. The second is the library. The library does have daily deliveries, but generally it's, books traveling between different libraries of the county and delivering. Most of this, I'm told, is done with a van or, a smaller little box truck typically. This is not semi or 18-wheeler type vehicles, very small, maintenance vehicles that would be doing that. And other maintenance vehicles doing maintenance on the facility as well. So again, the covered is very important to this whole design and what we're trying to do here. The back of house, as we mentioned, is on 2nd Street. It's shown on this map that you're looking at here. The driveway apron to it, which you can see is the bottom left-hand corner. And the reason for that location is kind of a few things. One, there is a requirement to keep it away from any intersecting street as far, I think it's 200 feet, or I could be wrong on that, but there's a distance down, so we pushed it as far away from that intersection as possible to keep away from conflicts with anybody coming out. But what that does also is allows this backing in movement. If you look in Gray Street, you see kind of a cross-hatch pattern. That's an auto-turn software we ran. We modeled the type of truck, a WB50, that they'll be using primarily for the deliveries and show that we can make that movement relatively easily. That software is very conservative. I say that because it's typically, truck drivers are much better than that and can make it a lot tighter, but we make it, based on the model. Downtown, again, is a very different area. The way that the code reads is you can have on-street parking or on-street loading and unloading. That's not common anywhere else outside of the corporate 45 limit, but here it is. We could put it on 2nd Street. The problem with that becomes then we cannot meet the requirements for the protection of what's being taken on and off. That would also require a forklift in this case to make multiple trips across sidewalks to get in and out of that loading area with the merchandise. Typically, museum stuff is on a, pallet type delivery, so it would require a forklift. Library, maybe not so much unless they're getting in large supplies or things like that. So again, that's why we're kind of opposed to that. With the on-street, we cannot meet that specific criteria. Also, if you put a semi on 2nd Street and we kind of look at it, if it went along the frontage there, it would start to cause possibly some conflicts with the parking garage and cars coming out. We could fit the vehicle there, but then you got to look behind the vehicle where all the unloading takes place in the forklift, and that's really where we would start to see some conflicts. And that's, another item that I think is very important here because it's, one of the questions is this in the best interest of safety and the general public? And we believe this reason wholly, supports our reason for putting it underneath the building. With that, I'll be happy to answer any other questions. I think we've outlined kind of our case here and our 4 findings of fact and the reasons that we, feel strongly that that this is important for the use. And also, I'll make mention of one other note. This is nothing uncommon. This has been approved for PPD. It's been approved for the Wilson Center. It's been approved for the Convention Center. All these have their loading zones, and obviously they have large vehicles that come in there from time to time, and it requires them to back in to their lots. So I'll leave it at that for now. If you have any further questions, I'll feel free. I'm happy to answer them for you.
Thank you. Any questions for the applicant?
We don't have an elevation of that side, do we? Of what your proposed
No, I did not bring
enclosed?
an elevation. We did not submit one here.
So the answer is no.
It has. And just to add a little bit more, and I'm sure Mr. Boney could do a better job at this than me, but Charles, if I botch this up, please come up and save me here. But, basically we're looking at between 3rd Street and 2nd Street. Everybody's familiar with the area. There's quite a considerable elevation drop between the two. So when you get to the back of house here on 2nd Street, basically we have this loading area that we go in, garage door covered. So it's not a, just open, you can walk in from the street. It's secured, it's closed, it's secure. The only other door on the back of this building, there's 2 doors. One is, I guess I'm sure for fire safety, an exit door only. and a riser room door for fire suppression. That's it. That's the only two access points. As you get closer to Second Street, where we have there an elevated patio, again, that's trying to make up some elevation differences from the building. So it's not a, we don't have a lot of access to the back of that building. No access for the general public, so.
I'll need to be sworn in.
There are other people who came in after the clerk swore in staff and the people who were wishing to speak. If they'd like to stand and be sworn at the same time, that would be very convenient. Sam, Frank.
If everyone could raise their right hand. Do you swear that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Good, thank you.
And Mr. Boney, if you could just state your name and your credentials, please, before you testify.
Yes. I'm Charles Boney Jr. I'm an architect. I've been a practicing architect in Wilmington all my life, almost. Not yet, but I'm a native of Wilmington. I know this community very well, and I'm proud to call it home. We've been working on Project Grace. Levi behind me here has been working hard on Project Grace, pulling this together. It's been a design that's been a labor of love for our office, and we've certainly given it a great deal of importance. Mark, you asked regarding the elevation of that side, and that is, as you can imagine, somewhat the service entrance side, but we've tried to give it some grandeur as well. And I'm sorry we came here to talk about transportation
maneuvering
and maneuvering and truck maneuvering as well.
Being an architect, I'm more interested in aesthetics than maneuvering, but maneuvering is important.
Well, one of the things that has driven us towards the design has been respect for the Borst building and realization that we need to take that building down, and also realization that the Department of Interior, or the Secretary of the Interior, as part of a contributing structure listed was listed as Wilmington's application for a historic preservation. We are, in taking that down, we're restricted to the height for the new building that we can place back in that location. And there's some other restrictions as well. So the design of that building has been part of that process. We have a solid wall along the facade where the loading dock is. It transitions to glass, as you can imagine, when we begin the introduction into the library itself, and becomes a glass wall along the north side as well, and when it becomes really the library proper, and the transitions to the museum as well. There's a very rich description of that whole building process and the stone walls that we're using with respect to the ballast stone of our heritage. The fritted glass walls on the library side are reminiscent of the translucency of papyrus that we even wrote on years ago, but the history of the libraries and history of the region there. So it's a very important building to us, and I think we have done, while we came here to talk about transportation, I think we've done a pretty good job locating that loading dock where it is and as it is, in order to make the thing the best possible project for the city. So I hope you'll agree with us and with the findings of fact. Any other questions?
Have there been any traffic impact studies done for this?
No, there has not been at this time. The redevelopment for this project, as you know, is not just the museum and library. It's more than that. So these uses here are not tripping that threshold, but it will be in future phases, and that's when it'll be evaluated.
But he did do the turn analysis, so any direct traffic was done. I would like to, for the record, before I forget, enter both Mr. Boney and Mr. Balland as experts if there's no objection. Thanks. And I would also like to point out that the county did an extensive space needs study for both the library and the museum, and so we are trying to be respectful of that as well. So getting trucks on site and turning them around so that they can safely back up and protect the precious cargo would drastically impact the space needs assessment that the county conducted for both the museum and the library as well.
Thank you.
Any further questions?
I just had a question. What exactly is the process when you get a tractor trailer like that and you're trying to, are you blocking off traffic? How do you handle backing a truck up along Second Street and trying to maneuver into that?
Well, I'm not going to say I'm a truck driving expert in any way, but from what I've seen down there and what typically happens, a lot of them will pull up with their flashers on, and they'll kind of sit in that right lane in that shoulder and wait for cars to pass, and they'll make that move, and it's either that or they've got staff that'll come out when they know they're loading or unloading and stop traffic briefly just so they can make that quick movement. You see it a lot down here. I see it a lot down here, every time we're down looking at a project or trying to, survey something and look at it, you see different movements, whether it's delivery trucks or even trash trucks. Have kind of the same thing. The general public knows, they see it, they watch that truck move over, they just stop and wait because they know they're making, a movement they need to make to, pull in and grab trash or whatever it may be. So that's why I say it's kind of, we all know we're all natives here and go downtown, but it's very different downtown and how it operates. But
they try to schedule those deliveries real early in the morning or something like that, or when it's not.
Yeah, and again, I say truck drivers are very, intuitive as to what's going on around them and what makes their job easier and what makes their life work. I think for the most part, that's going to happen. I think, I can't speak for when these, museum exhibits come in. I don't know where they're coming from, if they have that luxury of showing up at 6 a.m. But I think if they, find it easier, they're going to do it more often, so.
Okay, thanks.
Any further questions of the applicant? Thank you. I'm open the public hearing. Is there anyone here to speak in favor of or opposed to the requested variance? I'll close the public hearing and open it for board discussion.
I'm okay with this.
I'm okay
because
with it too, so.
Yeah, it's all good.
I feel like the impact would be more if they're parked on Second Street wheeling the stuff in than it would
Well,
be
by
to back
right,
it
they
up.
can park on Second Street and drive forklifts across the sidewalk. So I think this is a much better alternative than what's allowed. So I'm in favor of the variance.
Second Street was definitely the best choice, so.
Do we have a motion?
I'll make a motion to approve the variance for off-street loading facilities not, so they can be constructed, so all maneuvering takes place within property lines.
We have a motion to approve the requested variance. Do we have a second? All in favor?
Aye.
Aye. Opposed? Thank you. With everyone's permission, I'm going to move to item 10 while Graham's up here. Board Member Hovis also needs to recuse himself from item 10, which is 411 South 2nd Street. So we're going to jump out of order a little bit. So Jeff doesn't have to walk back up here and then walk back down there. So. Take a recess? Okay. Been requested to take a 10-minute recess. Thank you. If everyone could take a seat, I'd like to call the meeting back to order. Thank you. Next item before the board is item 10, which is 411 South 2nd Street. This is an appeal of the Historic Preservation Commission approval of the Certificate of Appropriateness.
As Chairman Moore said, this is an appeal of a decision of the Historic Preservation Commission to grant a certificate of appropriateness for a new one-story, three-car garage at 411 South 2nd Street. The appellant has an interest in the neighboring property. We do have the attorney for the Historic Preservation Commission, Attorney Huffman, here to present the record on appeal. And it is my understanding that there may be a threshold issue to work through prior to hearing any facts of the case. So I will go ahead and let one of our attorneys speak to that.
I just received a copy of a motion to dismiss the case based on the lack of standing by the person making the appeal. So standing is a threshold issue. Y'all know me, I'm Dolores Williams. I'll be advising the board today. So standing in this particular case and in all cases means that you need to be either the owner of the property or a governmental entity such as the city or the HPC that would have a special interest in this case, or the other kind of catch-all one is as an individual or an entity, you would suffer special damages as a result of the decision made by the HPC. So the argument, and we can hear from the parties as to this, but if you decide that the person who filed the appeal does not have standing, that means you do not have authority to hear the case, and that will be the end of it for today.
Okay, thank you.
Okay. Mr. Chairman, I would suggest that we hear from Attorney Matt Nichols. He is representing the property owner of 411 South 2nd Street. That property is the property which the COA was granted.
Okay, thank you. Mr. Nichols.
And he has provided copies of the motion to dismiss should the board wish to receive a copy of that.
I would like to have a copy, please.
May I proceed, Mr. Chairman, or should I wait?
Yes, please.
Thank you. Good afternoon, Mr. Chairman, members of the board. My name is Matt Nichols. I'm an attorney in Wilmington. I represent the property owner, Dr. Neil Beard. He owns the subject property, which is located at 411 South 2nd Street. He, through his architect, was the applicant before the Historic Preservation Commission, and he is the owner that received the certificate of appropriateness that is now being appealed. So we would respectfully contend under the statute that first, we have the right to be in the proceeding under Chapter 160D of the general statutes as the property owner. And we are moving to dismiss the appeal that was filed by Jeff Mason and Jennifer Blomberg. And I'll go through my motion, but I have an exhibit that I think will help explain the motion. And while that's being pulled up, essentially the applicants in this case, Mr. Mason and Ms. Blomberg, they are not the property owners. In fact, from what I can tell, they don't own any property in the vicinity, and they're certainly not adjacent property owners. The property that they were speaking of is owned by Blue Twilight, Inc., which is a North Carolina corporation. They may, in fact, be the sole shareholders of that corporation. I don't know, but that makes no distinction here. The property owner is a legally distinct entity, which is a corporation, and we would respectfully contend that that is the party, the real party in interest. If there's any alleged damage to the property, which we would deny, but if that's the allegation that's being made, it's made to the property owner, Blue Twilight, Inc., which is not a party to this appeal, did not appeal anything. If there's any alleged damage to the business that operates on Blue Twilight's property, it is damage to Blue Twilight, Inc., the corporation. And I attached both the deed to Blue Twilight to the motion to dismiss, which is Exhibit A, and Exhibit B even goes further to show that the real entity doing business at that location is Blue Twilight, Inc. So if it's possible to pull the exhibit up, I can show on the diagram the relationship of the parties or the properties, but the law in North Carolina is very clear. I cited a case in the motion to dismiss, and I will read a few excerpts from it. It is a North Carolina Supreme Court case that was unanimously decided. It was authored, written by then Justice who is now the Chief Justice of the North Carolina Supreme Court, Justice Newby. As mentioned in that, and I'll quote from the Supreme Court opinion, this is in 2020, that once a corporate form of ownership is properly established, the corporation is an entity distinct from the shareholder, even a shareholder owning 100% of the stock. The court goes on to say that even a corporation owned by a single individual is a distinct entity from its shareholder. The court also states that this rule ensures that a shareholder who forms a corporation to secure its advantages cannot disregard the existence of the corporate entity to avoid its disadvantages. And the court states that in this case, we decline to overturn this long-established precedent which has informed North Carolina corporate law for over half a century. So this is well established that the corporation is entirely separate from its shareholders. As shown on this, the property is owned by Blue Twilight, Inc., the properties that they'll speak about and the business that they'll speak about. And we would respectfully contend that that is the real party in interest. That is the party that perhaps should have filed the appeal and would have the arguments and the alleged damages, if any. We contend there's no damages presented by this. But as a threshold issue, standing is it's a threshold issue in any case. Your ordinance speaks in terms of the appealing party has to be an aggrieved party, and that's a specific term under North Carolina law. We contend they're not aggrieved parties. If there was an aggrieved party here, it would be the property owner, it would be the business operator, it would be Blue Twilight, Inc. They did not appeal. They didn't sign the appeal. Their name's not on the appeal. So we contend that should be dismissed. And we have other arguments as to the other parts, but that threshold issue, we would respectfully contend that the appeal should be dismissed for lack of standing. Thank you.
Thank you.
You need to hear from the other side as to their
Correct.
standing,
Yes.
what they allege.
Hello, Board Chairman. My name is Jennifer Blomberg. I am owner of Blue Twilight, Inc., president of Blue Twilight, Inc., which owns 412 South 3rd Street here in Wilmington. And I did file the appeal as president from Blue Twilight, Inc. of Jennifer E. Blomberg to 411 South 2nd Street.
So your appeal was filed as Blue Twilight, is that correct?
Filed as me as the president of Blue Twilight, Inc., and filed as my husband as secretary, Jeff Mason, of Blue Twilight, Inc., which owns 412 South 3rd Street.
I am looking at the application for appeal, and I do not see Blue Twilight noted on the application for appeal anywhere. I see Jeff Mason and Jennifer Blomberg. Jeff Mason and Jennifer Blomberg, and signatures, Jennifer Blomberg and Jeff Mason. But I don't see Blue Twilight on your application for appeal from an action of Wilmington Historic Preservation Commission.
We are owners of Blue Twilight Inc. and presidents of Blue Twilight
I
Inc.
understand, but I do believe the appeal needs to be filed by Blue Twilight and not by you as individuals.
Do we have any documents of proof of the shareholders or who all are the owners, actual owners? Obviously, we can hear her verbal statement. Do we have any documents that prove those are the only two owners of Blue Twilight?
Do we have a certified copy of the deed from the Register of Deeds?
There's corporate filings with the state.
Perhaps she has some other information. I mean, the C.W. Worth House was a bed and breakfast. Is it still a bed and breakfast?
It is still a bed and breakfast. The Blue Twilight Inc. is doing business as C.W. Worth.
And who's the manager of the B&B?
Is myself and my husband, Jennifer Blomberg, Jeff Mason.
Who resides in the B&B?
Jeff Mason and Jennifer Blomberg.
Are there any shareholders in your corporation? Although that's probably irrelevant, the board asked the question.
I can answer there are not. They're just myself, Jeff Mason, and Jennifer Blomberg are the two shareholders of Blue Twilight Inc., which does business as the C.W. Worth House on 412 South 3rd Street, and that's also our primary residence at 412 South 3rd Street as individuals.
Mr. Chairman, I attached the copy of the deed. I don't think that's in dispute. There's no dispute that Blue Twilight Inc. is the owner. And again, I would respectfully say it doesn't matter if they own 1% of the stock or 100% of the stock, or one of them owns 100% of the stock. The cases and the law is well established that it is a separate legal entity. They can't have it both ways. They can't own it as a corporation and then act as individuals. And they have clearly signed this as individuals. Doesn't look like I mean, Blue Twilight, I don't think appears anywhere on the appeal document. It's not a mistake of signature, and I'm not disputing that they are the shareholders or they're the president. We would respectfully contend that based on the clear distinction between the corporation and them as individuals, the case should be dismissed.
Okay, just to be clear, the owner of the property that obtained the COA is definitely a party in interest. The question comes in when you're not, say, the owner of the adjacent property, but you have some kind of interest in that property. For example, I think you don't only have to be the owner. You could, what if you were a tenant? Would you be able to file an appeal if you had rented the house and you were living there? Would you be able to appeal that decision? You're not the owner of the property. Perhaps you could address that if you could show special damages.
Well, the ordinance is clear. It says you have to be an aggrieved party. So that means you have to have some damages, some pecuniary or special damages distinct from the rest of the community. Now, any damage that they're alleging would be, say, for instance, I know they have an issue with a tree on their property. That tree is owned by Blue Twilight Inc., the property owner. The business is run, we've attached the DBA that they filed with the New Hanover County Registry. The real party operating the business is Blue Twilight Inc. But just because you live in the vicinity, that doesn't give you standing.
But
We're
it
saying-
says.
she's saying own
any
or
other
interest.
person. It says any other person, so the person doesn't have to be a property owner, but they do have to show they have special damages. Any other person who will suffer special damages as a result of the decision being appealed is an aggrieved party under the North Carolina General Statutes.
Oh, again, I don't know what, the interest in the property is 100% owned by the corporation.
I don't think anybody denied that.
I don't.
You said own or have an interest, correct?
Oh, it says, any other person who will suffer special damages as a result of the decision being appealed.
This is nonsense.
Person, any other person. It doesn't say any other property owner, it says any other persons, but they do have to show special damages. And we haven't heard from the person appealing as to what the special damages might be. This is the time for them to make their case at this hearing.
This is my time to why I have the appeal, or I have a presentation if this was to move forward
it's-
that I would love to show
No
why
presentation yet. You have to show the board that you will suffer special damages if this decision remains. The HPC decision stands.
That is what my appeal is based off on. If I am able to do a presentation, I would definitely like to show that to you. Our appeal is based off the potential damages, documented evidence that the construction on this property will cause mature trees on my property, also adjoining properties, to die, have to be removed, and also a significant amount of vegetation that will have to be removed on the applicant's property, and how this goes against the Historic Commission on what their purpose and role is. It violates numerous design standards, also the Secretary of Interior standards that they are supposed to follow by knowingly destroying. We have a large pecan tree in our backyard. Professional experts have come in and said that tree will not survive this construction. It will die with no preservation measures. Will save this tree. Also being affected by this construction project is a live oak that is 1 foot from the property line on adjacent property. There is another elm tree and another oak, and 2 other pecan trees that will be all, according to experts, suffer from this construction and will die. That is the basis of this. There's also other issues that were brought up to the hearing in both hearings for this, that there's going to be drainage issues, massive amount of cement brought in. These are all impacting surrounding properties and, cause long-term effects for other property owners surrounding this one property applicant, including my property. Decisions were made about my property in reference to one application that was put against the Historic Commission Board. And that's the basis of my appeal, is not losing a significant feature, site feature in my backyard, which is what the Historic Preservation Commission's purpose and mission is to help protect in the city.
The things that the courts have found to be special damages include noise, light pollution, traffic, parking, safety, security, stormwater runoff, and littering. Though there've been cases on those. Not to say it's exclusive a list, but it will give you an idea of what the court sees as special damages.
Well, in addition to that, the Barrett survey that was done by the tree experts say that this construction will cause this pecan tree to die in my backyard, which is making it a future hazard. A future hazard that this tree will be impacted by wind and storms that frequent our area, and that causing this tree to fall, which puts all the surrounding properties at damage and risk. And in the Historic Preservation Commission, their resolution to this and their solution to this was for the applicant and for all surrounding properties to lawyer up to protect themselves and to protect their property and their sites. So damages are documented, and there's evidence that there will be something in the future that would cause property damage to Blue Twilight Inc., to myself as president of Blue Twilight Inc., and to surrounding properties due to the construction on this property and surrounding mature trees that will be impacted.
Any questions from the board?
Mr. Chairman, if I may.
Yes.
And I realize usually we have tables set up.
Can you speak into the mic, please?
Usually we have tables set up, so I don't want to be necessarily approaching the podium when others are speaking, but I do feel the need to object to a number of the things that were said, that there is some sort of tree report in the record. It doesn't say what she just said it says. So we definitely have an objection to the factual statement that was made. In addition to that, I believe she just said that the damage would be to Blue Twilight Inc. I think she's admitted that. And she said it would be to her, damage would be to her as president of Blue Twilight Inc. Again, I think that's proving the point of the motion to dismiss, that Blue Twilight Inc. is the real party in interest here. She said something about, and she mentions it in her appeal, about someone told her to lawyer up. I don't know who told her that. But they did not get an attorney to help them with this appeal. And I would only think that that would have been filed differently. But the reality of it is they did not file the appeal properly. It's not just a technical issue. It goes to the standing of their ability to file this appeal from the HPC to this board. So if the matter does proceed on, we certainly object to the factual statements that were made and the summary of the facts. And we would certainly object to the introduction of anything new that was not before the HPC, because this is purely a review of that record and the facts at those hearings. Thank you.
Thank you.
The report that I have referenced is in your appeal package. It was presented to the HPC. It's from Bartlett Tree Company. It is all stated right there that this tree will decline. It got a rating of 56 out of 100, and it says in the summary it will be expected to decline during and shortly after construction. That is factual and has been presented to the HPC. The lawyer up was actually addressed in both hearings. In both of the HPC hearings, there's multiple discussions. There's a whole lengthy part of the minutes and the transcripts and the audio that talks about the board talking about the lawyering up and by hiring attorneys, and this is a civil litigation, not a government issue. This is factual, and it is in both the hearings.
We're still talking about whether they're standing or not, and per council's statement, it says any person, or excuse me, anybody with any interest. It doesn't have to be the owner. I don't know why you keep talking about owner. That's not what it says.
But it has to be a person who will suffer special damages.
So I don't understand why you keep saying the same thing over when that's not what it says. Not everybody needs an attorney to then file something that doesn't even make any sense.
No, they have to be an aggrieved party, meaning they have to have damages that would be distinct from the rest of the community, which usually and invariably means you are going to suffer some sort of damage to your property, some pecuniary loss, not just I live in the community and I am going to miss that tree being there, or my view is going to be different. It has to be something that's different from the rest of the community. My contention is that the property owner, because they're raising issues about a tree that is on the property, that's an issue for that property owner. That's probably the main issue they're raising, is an issue about a pecan tree. And these individuals, they do not own the property, and they're admitting that. So while the ownership is not the sole determining criteria, they do have to show how they're going to be damaged, distinct from the other.
Any person of interest, and they live in the property.
Of course, it's up for the board to decide. I respectfully make the motion. We contend it's based upon what we would say is well-established law, and the property owner is the proper party to the appeal. The property owner has not filed the appeal.
Mr. Chair, may I be heard on behalf of the city? On behalf of the city HPC? I don't think I've had an opportunity to weigh in on this standing issue.
True.
Okay. Mr. Chairman, I join with Mr. Nichols in arguing that the applicant in this appeal has not properly shown standing. I'm actually looking at the statute 160D 1402 subsection C right now. So the three ways of ownership interest that we were just talking about, that's one way of showing standing. If they had an ownership interest in the property, that was subject to the appeal. Ownership interest, in my view, is, again, I think Mr. Nichols made a good point. If you have a corporation, that corporation has the ownership interest. Members and shareholders can come and go, but that corporation is the one that's on the deed. In my view, they do not meet that criteria. The other criteria I think this could come under would be the any other persons, it's subsection C2, any other person who will suffer special damages as a result of the decision. I think that what we're getting at here is that special damages that are specific to those applicants as people. That has not been alleged. And again, I don't mean to keep repeating what Mr. Nichols said, but yes, there are trees in the neighborhood. Those trees, the loss of those trees in that view would actually apply to every person on that block, every person with adjacent property, every person with an interest in those properties. But those folks aren't here right now, and that hasn't been alleged. Why would this be special to only these two individuals? Not to the corporation, but these two individuals, and not to everyone else in that block would be, I guess their view would be affected by removal of trees, which is not necessarily, and this is for the argument of standing, trees are not actually going to be removed as a part of the project. That's part of the record on appeal. So that would be my argument. I weigh in on the side of Mr. Nichols. And then we can just see if you all find standing, we're ready to proceed on the record on appeal.
Thank you. Discussion from the board?
Yeah, I mean, my view is, even though it's a corporation, these are the shareholders, they're the people that live in the property. They're the ones that are going to have to do something if that tree does die. The corporation doesn't do anything unless those shareholders do something. To me, they are the people that would suffer special damages. I think they do have standing. That's the semantics of a corporation and who the shareholders are. That's something that can be dealt with later, on appeal of this decision, or our decision. But to me, just because the other property owners didn't come forward to protest this, or they may be here to speak against this, the fact that they didn't file anything, I mean, they're not the most directly impacted by this. This property is the one that's mostly directly impacted. So, my feeling is there is some merit to the fact that they will be the one that are suffering the damages.
Okay. Dolores, will we make a motion and put to a vote of the board as far as standing goes, or how do we determine standing?
Basically, you would just make a motion one way or the other that based on the information presented to us today, we find that the applicants for the appeal do not have standing or do have standing.
Thank you. Mark, you want to?
So, Dolores, obviously this appeal of the HPC's commission has to be done in a timely manner, so if we find that they don't have standing, are they able to refile this under the corporation, or is it too late for that, or?
There's a 30-day requirement for filing an appeal, so it would be too late. They would have to appeal your decision regarding standing to the Superior Court. And if the Superior Court reversed, it would come back to the Board of Adjustment to hear it on the merits, which is on the record.
Right, and if we were to rule today on this case, saying that they do have standing, what's then the appeal process for the?
If they do have standing, you would go forward with the case today, and you will make a determination of this appeal. And if the property owner who has a certificate of appropriateness desired to appeal, he would appeal both the finding of standing and whatever the determination might be if it is not in his favor.
To Superior Court?
Correct.
You want to propose a motion before the board?
I would propose a motion that the applicants do have standing, and that we hear the appeal.
I would second that.
All in favor?
Aye.
Motion passes. The applicant has standing. We can proceed.
Can you bring up the city's PowerPoint? Thank you. There are two, actually three. Is this yours, Melissa? Attorney Huffman. Mine only has like 5 slides. Okay, this is you then. I got it. Green. Thank you. You know, there's a city. Good afternoon. Again, this is the appeal of an HPC order for the property at 411 South 2nd Street. Oh. No, okay. Catherine, are you controlling it or am I? Here we go. Okay. Sorry. Okay. Background of the case, just briefly, April 14th, 2022, the Historic Preservation Commission held an evidentiary hearing at which multiple members of the public testified, including the applicant on appeal, Mr. Jeff Mason, and I'm sorry, I forgot to put Ms. Blumberg's name in here as well, but they were, I believe, both present, but certainly had the opportunity to testify. The hearing was continued for the property owner to address the Historic Preservation Commission's concerns. It was continued once more on May 12th, and then the second evidentiary hearing, or a continuation, if you will, of the first evidentiary hearing occurred on June 9th, 2022. At that time, the owner presented modified plans that reduced the height of the garage from 2 stories to 1, increased the garage's setback, and proposed additional landscaping. This was a part of the record on appeal, but those are hundreds of pages, so I thought a brief synopsis might help everyone. Mr. Mason, again, and multiple members of the public had the opportunity to provide sworn testimony as well as make presentations, and a certificate of appropriateness with approved conditions was approved. Okay. As you all know, appeals from the HPC are based solely on the record. No additional evidence or new evidence is allowed. The criteria that you have to look at there are 5 factors. Did the HPC commit an error of law? It's the HPC's contention that they have the authority to issue certificates of appropriateness with conditions. They're given that authority by the North Carolina General Statutes, the Land Development Code, and the Historic Preservation standards and guidelines. It is also our contention that the appellants do not allege that there was an error of law. They just do not agree with the decision that was made. The HPC accepted the evidence that was presented to them by the appellants, and I believe you all have seen that in your packet. And even in their appeal multiple times, it was stated that the Historic Preservation Commission heard this evidence, this tree evidence that was presented. The fact of the matter is the HPC just came to a different conclusion than the appellants, excuse me. Did the HPC follow proper procedures? They followed all of the procedures that are required of them by the general statutes, the Land Development Code, the Historic Preservation Standards, and its own rules of procedure. They also, it is our contention that the HPC did not violate any constitutional provisions, including due process. There was ample opportunity for members of the public to present evidence at sworn testimony, and that was taken advantage of by not only the appellants in this case, but other members of the community. All right. Is the HPC's decision supported by competent material and substantial evidence in the record? This is where we feel that it really gets into the meat of the argument. I will point out a number of places where the city's record supports the decision made by the Historic Preservation Commission. The staff report that is in your packet from the April 14th meeting included a list of approved certificates of appropriateness in the HDR, and this property is in the HDR, so it's the same district, that staff considered to be similar to this request, including one just in 2021 that allowed the construction of a pool and a pergola. It's a similar design of what was being proposed in the backyard of the subject property. The staff report also included evidence of the varying heights of surrounding buildings ranging from 1 to 3 stories. There were some concerns presented by neighbors and also reflected by the HPC commissioners about the congruity of the scale and height of the design at their April hearing. And then in June, the applicant came back with modifications to their design to help satisfy some of those concerns, and they succeeded in satisfying those concerns with 6 out of the 7 commissioners on HPC. The tree report that's been talked about quite a bit in our standing hearing just a moment ago, that tree report was presented by the appellant and was accepted into evidence, but much like with Board of Adjustment, the HPC is a quasi-judicial board. They can accept evidence that would otherwise be considered hearsay or not allowed by the courts, for example. But the quasi-judicial board has to give the proper weight to that evidence. So this report was presented, but there was no one from the tree company to speak to the methods that were used or how often they were out at this property. There was no one there to testify as to that report or to answer any questions from the Historic Preservation Commission. So as the finder of fact, the Historic Preservation Commission had the authority to consider the reliability of all of the evidence before them and weigh it against other evidence such as sworn testimony. And finally, was the HPC's decision arbitrary and capricious? And it's our contention that it was not. There are multiple places within the record that support the Historic Preservation Commission's granting of this certificate of appropriateness. And it's not just the tree, it was the entire design that was granted a certificate of appropriateness, including a 3-car garage, and I believe there's a cabana as well. This is more than just an issue over a pecan tree. And ultimately, the Historic Preservation Commission felt that this design was congruous with the neighborhood and the district as a whole. So, to conclude, because I know we have other evidence that's going to come after me, it's my belief that the board's decision is going to come down to 3 things. You all can find that the Historic Preservation Commission complied with those 5 factors that you are considering and uphold its decision. You could find that they in fact violated one or more of those 5 factors and remand the case back to Historic Preservation Commission with an order directing them to do whatever action would need to be taken. And that, for example, is if you decided that they did not have substantial evidence to rely upon for their decision, you could remand this back and order them to rescind that certificate of appropriateness, as an example. And finally, you could find that the Historic Preservation Commission committed a procedural error or did not include all of the necessary findings of fact on one or more of those issues we just talked about, and remand it back to the Historic Preservation Commission to correct whatever procedural error that may have been, or to make additional findings of fact consistent with your decision. Do you have any questions for me as the attorney for the Historic Preservation Commission?
Any questions?
Thank you.
We'll open up for public comment, I think. Thanks. Ms. Blomberg, did you have a presentation?
I have submitted a PowerPoint. I'm not certain if I'm able to use it or not. There is no new evidence in it. It's just a visuals to help guide my presentation. All visuals in the presentation are submitted previous to the HPC, included in the appeal package.
Dolores, I've reviewed, I don't know about the other board members, I have reviewed the tree report and others. Is it appropriate to allow her to proceed with the PowerPoint?
Only if it's already in the record. Do we want to hear from Attorney Nichols? Let's not forget that. Okay. Okay, proceed.
On June 9th, the Historic Preservation Commission approved a massive scale rehabilitation project at 411 South 2nd Street. This has devastating impacts on adjacent properties and the neighborhood and sets negative future development standards for the historic district as a whole. The approval violates and does not align with numerous Wilmington design standards for the historic districts and landmarks. These are outlined in the appeal. The Secretary of Interior standards for rehabilitation, also outlined in the appeal, and violates the overall mission and purpose of the Historic Preservation Commission. The HPC conducted willful and unreasonable action without consideration or regard for the evidence and facts clearly presented by neighbors of 411 South 2nd Street in both hearings. This presentation is based on the materials submitted to the HPC in both of these hearings and the appeal summary. Throughout this presentation, please remember this quote you see in front of you. This quote does come directly from the Wilmington Design Standards. Quote, "Trees are important natural features in historic districts. It is important that mature trees remain intact and undisturbed." End quote. These are the 4 topics focus of my appeal. Substantial evidence was submitted and presented to the HPC from several neighbors on numerous issues on how this project will impact surrounding properties and the neighborhood. Some of these concerns include the massive scale of this project, drainage concerns due to the massive amount of cement, potential property damage to surrounding properties, landscaping concerns, and the burden on a private alley that was not intended for this heavy use. The HPC was presented with documentation stating that this construction will destroy numerous protected trees on adjacent properties and will require landscape removal on the applicant's property. These trees include the destruction of live oaks, large pecans, fruit-bearing trees, barrier hedges, and hollies. Evidence was also provided to the HPC that this project will cause these trees to become future hazards to surrounding historic properties as they die from this project. The HPC's solution to the evidence was the recommendation to contact private attorneys and for civil litigation. Commissioner Joan Keston stated, quote, "Trees are a civil matter and private property issue." I apologize if I'm saying her name wrong. But, quote, "Trees are a civil matter and private property issue in a very complex area and way beyond what we can deal with and not allowed to," end quote. This is incorrect, and it is negligent on the behalf of the HPC to knowingly put other historic properties at risk. Why is the approval of a massive new construction project on one individual's property have more value to the HPC than the protection of all the other surrounding historic properties, structures, landscapes, and mature trees? It is also clearly defined in the Secretary of Interior Standards for Rehabilitation that this is not recommended. It is not recommended to allow, quote, "allow loss, damage, or destruction to occur to historic buildings, its sites, or settings by failing to evaluate potential future impacts of natural hazards." That's on page 153. This is a massive project with no other approved comparable projects in the historic district. This change to the neighborhood affects adjacent properties, numerous other properties, and the district by the standard what HPC is setting with this approval. The project drastically violates the overall mission and purpose of the HPC. The purpose of the HPC is to, quote, "protect the special character of Wilmington's historic district by preventing changes that are incongruous to the districts as a whole," end quote. I ask you, does this non-historic three-car garage look appropriate here in this setting? Appropriate for the surrounding properties? Does this keep the character of this site? The current site will be fully cleared of all trees and vegetation and paved over for this garage, parking pad, and covered patio. This garage will cover majority of this property and destroy neighboring mature trees on adjacent properties. If the HPC approves projects that destroy mature protected trees, are natural features in the historic district really that important to the HPC? Are they following their guidelines or only looking at the benefit of one property? Where is it in the Wilmington Design Standards that states the HPC's purpose is to approve projects isolated from the neighborhood, approve projects that put surrounding historic properties at risk for damage, destruction, and loss of important site features, including mature trees? It's not there. You will not find it. It states just the opposite. But this is just what the HPC knowingly did here. This project was for the approval of the following: modifications to an existing rear facade, the construction of a three-car garage, construction of a one-story cabana, installation of an in-ground pool with a hot tub and water feature, fire pit, the installation of a louvered fence, and landscape modifications. City staff found the following similar cases in the historic district for comparison review. 701 Chestnut Street. Install a wooden fence along the eastern side and rear yard. 120 North 8th Street. Change style of fence, move location of gate, change size of fence posts. 606 Chestnut. Remove existing rear addition and construct hip roof, 304 square feet, one-story addition with matching side and trim. Just the cabana alone in this proposal is approximately 560 square feet. Are these similar to you? They are far from similar to me. Staff found additions to existing structures, but nothing about completely new standalone structures like this. Staff listed a couple of pools, but no pools with hot tubs and a cabana. They did not find any similar projects that erect a 3-car garage. There is no comparable approved project to this mass scale. The idea that the city staff put these in the proposal as comparable projects is humorous at most to me. From this aerial view, you get a good sense of all the trees and the natural features that will have to be removed or will die from this project. With completion of this project, a majority of this land will be paved over. The historic district is not the location for this project. This looks like a beautiful project. It just does not belong in this area. We are a historic district, not a modern beachside subdivision. If this is acceptable to the HPC, what is this saying to other properties in the historic district? Here, the HPC approved what the future of Wilmington's historic district will be. It will be concrete, no trees, and forced neighbor litigation. They have now set the standard that it is okay to pave over the historic district and okay to approve mature trees. Let's look at the scale of this project in a smaller section of the proposal. The proposed garage is on a 45-foot by 66-foot wide lot. This is a total square footage of 2,970 square feet. The proposed garage is 36.4 feet wide with a 3-foot paved sidewalk proposed, leaving 5.5 feet of unpaved surface. But also keep in mind, in this 5.5 feet that's unpaved, this also must accommodate a cement 6-foot tall wall on the east side and the attempt to maintain a historic brick wall on the west side. The lot is 66 feet long. The proposed garage and covered patio area is almost 40 feet long. Then we add a 700 square foot paved area in the front of the garage doors. We are now over 2,145 square feet of pervious and impervious cement materials covering this lot, leaving only 825 square feet of unpaved land on this section of this property, which is a small portion of this development. This causes huge impacts to this property and neighboring properties, including drainage concerns, landscape removal and destruction, and the burden on a private alley. Again, the mass scale of this project, all the impact concerns, and the future hazards of this project will cause to this neighborhood was all dismissed by the HPC, and we were all directed to contact lawyers. Here you see the applicant's property outlined in yellow, mature trees in green, with red marking the critical root tree protection zone of the mature protected trees. This was thoroughly discussed in both hearings. If trees are so important to the HPC, then why did they approve a project that will destroy mature protected trees? Protection and preservation of protected trees is very clearly defined in the Wilmington City Code Ordinance. The pecan tree in the upper right corner is the tree that is located on my property. This is the tree that is documented to die from this project. A conservation suitability report from Bartlett Tree Experts dated June 2nd, 2022 was conducted for 412 South 3rd Street to assess the potential impact of this property to the mature pecan tree that borders the property line of 411 South 2nd Street and 412 South 3rd Street. This tree is about 2 feet from the property line and will be impacted by fencing, land grading, and cement slab foundations for the garage apron, and the covered patio area. This report was presented to the HPC in the June 9th hearing and is also included in the appeal package for your members. The report documents this pecan tree is not expected to survive the construction and can be expected to decline during and shortly after construction, regardless of any preservation measures. According to the tree experts, this data will also apply to all the other mature trees in the construction area that you just saw, this being a live oak, other pecans, and an elm. The report also predicts that this anticipated root disturbance that will happen with this construction due to the cement and the weight on the roots, the tree will have a highly likelihood of failure during high winds that frequent our area. This putting all the surrounding historic properties at risk for damage. The HP solution to this was the recommendation to lawyer up. It is also in the design standard stating, quote, "It is not appropriate to build a new garage or accessory structure if doing so will distract from the character of the principal building or will require a removal of an important building or site feature such as a mature tree." I understand that they are not reporting that they are doing removal, but as this report says, they will destroy trees in this process. The Secretary of Interior Standards for Rehabilitation also does not recommend, quote, "introducing new construction into historic districts which is visibly incompatible or that destroys historic relationships within the setting or which damages or destroys important landscape features," end quote. Protected trees are important landscape features. It is clearly defined in the City Code of Ordinance, quote, "Protected trees may be removed only if essential site improvements, as defined in Article 15, cannot be accommodated elsewhere on the site." A new three-car garage does not fall in the definition of essential site improvements, and the garage can be accommodated on the site without removal of these protected trees. The applicant has an existing driveway on the other side of the property. This was presented to the HPC and dismissed as a member on the board stated the applicant wanted the pool behind the house, not the three-car garage. In addition to these mature, some protected trees that will die on adjoining properties and become hazards, the following trees will also have to be removed on the applicant's property to be able to construct this proposed three-car garage. All this destruction was presented to the HPC. Just in the area of the proposed garage, over 14 mature, some protected trees will need to be removed or are not documented that they will not survive this project. This is a major clearing of land in the historic district. According to the Wilmington Design Standards, major landscaping involves alterations to or the addition or removal of more than 5 trees or plantings. In the April 14th hearing, Mr. Wilson asked about a landscaping plan and expressed concerns over tree removal. Commissioner Keston pointed out that staff recommended the landscape plan be done through the bypass process. According to the Wilmington Design Standards, quote, "significant landscaping that could impact adjoining properties requires a professional landscape plan," end quote. Where is this? It also states destruction and possible removal of protected trees does not fall under the Wilmington Design Standards definition of administrative bypass for minor work. Here are the main trees that will be immediately impacted by this project. You have a beautiful live oak to the left, a pecan in the middle, a Japanese maple, a pomegranate, gigantic fig, and some barrier hedges. In the June 9th hearing, Joan Keston stated, quote, "We've never been asked, nor do we ever weigh in on the impact of property construction on neighboring houses beyond congruity issues, mass, scale, that sort of thing, and anything else is beyond what we can deal with," end quote. But this is about mass, scale, that sort of thing. The HPC did weigh in on property construction impacts on neighboring properties by making a ruling that knowingly impacts these properties. How can they make a ruling that highly impacts neighboring houses, puts historic properties at risk for destruction, and then tells the applicant to lawyer up to protect the other properties and features due to the documented impacts that this project will have? They are forcing the applicant and numerous neighbors to enter into civil litigation so neighbors can protect their homes and properties because of the HPC's decision for one application. According to the design standards, rulings are not isolated from neighbors. It clearly states, quote, all design decisions about individual properties should be made in conjunction with what is appropriate for the surrounding properties and the district as a whole, end quote. This ruling clearly is not in conjunction with what is appropriate for the surrounding properties and the district as a whole. According to Joan Keston in the April 14th hearing, she also states that 411 South 2nd Street should have the right to do what they want with their property. Really? Do we? Do they? We live in a historic district that is governed by guidelines and standards that protect the historic nature of our neighborhood. 312 South 6th Street got declined installation of an 8-foot fence. 8 South 7th Street got declined exterior alterations of a chimney. 505 Ann Street got declined change of roof material. Why did these properties not get allowed to do what they wanted with their property? It is the responsibility of the HPC to enforce and protect the character of our historic district, not the interests of one property. If we do what we want within the historic district with our properties, including paving over our properties, destroying mature protected trees, destroying property and site features on neighboring properties, what is the purpose of the HPC? What do they stand for? Under this commission, the future of Wilmington Historic District is at great risk. As a historic preservation professional myself, and have lived in historic districts most of my life, I am appalled at the city for the lack of protection and preservation and the historic that we're losing with this kind of decision of our historic properties and our features. Did the HPC commit an error of law? I'm not a lawyer. I can't answer this question, but I do question and comment on two things here. I question conflict of interest in the approval. One commissioner is a neighbor directly across the street from the applicant. She did not excuse herself, did not feel a need to excuse herself. I cannot see how she can be an impartial decision maker with her proximity to the applicant. I question the morality of the commission. One of the commissioners stated on the April 14th hearing, quote, "How can we approve a project that does not take all of these concerns into account? Morally, we have a responsibility to look at this," end quote. I agree. Where are these morals other than the HPC deflecting to civil litigation and to contact state representatives? Did the HPC follow proper procedure? I say no. This approval for this application does not comply with numerous Wilmington design standards for historic districts and landmarks. The HPC knowingly approved the destruction of protected mature trees, removal of fruit-bearing trees, the removal of natural barriers, and knowingly put other historic properties at risk for damage through drainage issues and tree failure. The only comment from the HPC on this issue was, quote, "These are not government issues," end quote. But the government is knowingly approving this project and overlooking the evidence that was submitted. Where is the HPC's liability in their actions? Were the applicant's due process rights protected? In this, I say no on numerous accounts. Some of these include evidence from professional companies was submitted to the HPC. This was all disregarded. Cross-examination was mainly the applicant and the architect stating that the neighbors have been talked to and or they will talk to neighbors. And a lot of their answers to the questions and concerns addressed was, quote, "That is our intent," end quote. These are vague answers that do not provide attendees the right to comment or cross-examine. How can you comment on siloed discussions that you are not part of, that are not in the hearing? All plans should have been required to be outlined in the discussions and the application for review and comment with all parties. The board complimented and praised the applicant openly throughout the hearing. They praised the applicant, the work previously done on the property, and their personal character as neighbors. This type of behavior is persuasive and intimidating. This persuaded the board members, this could have persuaded the board members' decision-making process. It also intimidates neighbors that could have disagreed with the project and did not speak. The hearing is not about the applicant's character. I'm sure they're very nice guys. It's not about the previous work done. Their house is beautiful. It is about the proposal at hand. There needs to be an unbiased, neutral hearing for all parties to express their concerns and be heard by a board that does not have a fixed opinion on the hearing. Is the HPC decision supported by competent material? No. Is an incomplete application, which I have told you about. The board was content with the applicant and the architect answering questions with, "That is our intent." That is our intent is not the basis for a competent decision. It is not a plan. It is not something boards should be able to rule on. Was the HPC decision arbitrary? I argue yes. There is no comparable proved projects on file, and they did not follow their own guidelines cited throughout this presentation. The project is massive. The project is at a scale. It does not follow standards and does not belong here in our historic district. Thank you for your time.
Thank you. I need to make everyone aware that Scott needs to leave at 3:45. So we've got about 15 minutes before he will have to leave. Thank you. Are there any questions from the board for Ms. Blomberg?
The property which then forms the L shape, so that block of land behind 407 and 409, that was sold by the Worth House,
Correct.
which is,
Previous to me owning that,
when
yes.
did you buy? Because it was just last year?
Purchased in February of this year. There was a land swap that is in the hearings and discussed in the hearings, yes.
Any other questions? Thank you. Mr. Nichols?
Thank you, Mr. Chairman, members of the board. I'll try to be brief, but I do want to cover the points. This is very important to my client, the property owner who is trying to maintain and do a nice project on his house in the historic district. I have here Rob Romero, who is the architect, and he was before the board on both hearings. I may ask him to comment on a few of the things that were said because we would respectfully contend it not accurate as to the tree issues. again, but I'll try to keep this brief. This is my printout of the record. I know you all have that. It's one of the biggest records you'll see in one of these things, at least in my experience. And the HPC conducted a full, fair hearing, and they had the opportunity to say a lot of these things. Some of it was said, some of it wasn't. I don't recall looking through the minutes and the video that Ms. Blomberg even said anything at the HPC. So I think her statements to you today are her statements in this proceeding, but I don't believe she spoke at the hearing. At the first hearing, Mr. Mason, who is one of the applicants in this, he didn't bring up trees at all. We can bring, maybe if I could bring my presentation up, I think I have an excerpt of the minutes. It's in the board's packet, but the concerns that I recall were the massing and the scale. And as a result of that, and other comments that were made, my clients, the matter was continued from April, and then it went back to the HPC in June. Another full hearing in June. Everyone was given an opportunity to speak. And my clients had come back with, I think, a significantly scaled down garage. It went from 2 stories to 1. Also, so my clients were addressing that. This is from the April minutes. You can see the 2 sentences there from Mr. Mason, the appellant. He spoke in opposition, citing concerns about a 2,800 square foot structure adjacent to his backyard. My client addressed that. He also said there was an issue with the right-of-way. I understand that was addressed. The impervious surface and the parking pad in front of the garage as a condition of the HPC approval was turned into permeable pavements, I think, for purposes of drainage and trees. The decision in this case from the HPC, which is the fact finder, so the HPC is the fact finding board in all this. The decision is 7.5 pages single spaced. It's very detailed. They're the ones that heard all the evidence, and they decide the facts. They decide the issues that are being raised today, and they did decide those as far as scale and massing and congruity with the district. And it was a 6-1 decision. It was an overwhelmingly positive decision in favor of issuance of the COA. A couple other things I'd like to note are there's a mention about the Bartlett. It's called they're calling it a report, but really it's just a worksheet. I know it's in the board's packet. It was attached to the appeal document, and I hear things about they're saying the tree's going to die or there's a likelihood that the tree's going to die. That's not what the report states. First of all, it's a conservation suitability worksheet. The top of it states that it provides that it's an arborist evaluation tool, and then it said this guide is just one tool and should not be used as a sole determinant of a tree's suitability. Now, the arborist, to my knowledge, he wasn't at either of the hearings. He didn't speak to my clients. He didn't get into the methods of construction that were going to be used. And on the second page, now this is attached to the appeal document, but I didn't see it in the record. This is, I guess, the second page of the report. To the extent it's not in the record, I would just object for the record. But assume for purposes it is in the record. It says right on it, it says, while this is not a tree risk assessment. So it's a suitability report. And he doesn't say the tree's going to die. He talks about how there would be approximately 50% or of, I think that's a typo, root system likely sustaining damage, and then the tree is expected to decline during or shortly after construction regardless of any preservation measures put in place. We're not proposing to remove the tree. It's on their property, and there's no intent to remove that tree. There's another tree that was shown. We're not removed. There's a large tree that's on the other side of the property that I think Ms. Blomberg indicated was going to be taken out. It's not. It's right on a fence. I can have Mr. Romero speak to that. But we would contend that the HPC properly evaluated the evidence. This gentleman wasn't there to substantiate the report. He couldn't answer questions. I think it's speculative in many ways. and we don't know what methodology he used to determine that. So the HPC had considered that. Ms. Blomberg mentioned that. They fully evaluated the evidence, and they are the trier of fact, and they made their factual findings, and they made their conclusions. And I would respectfully say there's not been any basis stated, no legal basis or basis in the ordinance or basis in alleged errors of law that would warrant reversal or disturbing the HPC's decision, which in all respects looks like it was a very thorough hearing, very thorough, thought-out certificate of appropriateness was issued. And a couple other points I'd like to make. I think the question was brought up there, right, the property that part of this was on was, I think, originally part of the Worth House property, but that land swap, so to speak, that took place before the appellants here even bought their property. So when they bought their property, my client owned that behind them, and he has the right to use that within the requirements and provisions of the Wilmington Ordinance, and following the procedures is going to the HPC and getting a certificate of appropriateness. So we would respectfully contend, as Ms. Huffman pointed out at the beginning, that this is a review proceeding. There was a full fair hearing. I think Ms. Blomberg mentioned something about a conflict of interest that was never raised. I don't think that's fair to raise that now. There was no objection to one of the board members sitting there. And I would contend the issue that she's raising, the board member that was a neighbor who would be looking at this, I think, with probably a very keen eye, so to speak, as a neighbor. The chair, she voted for it. So, but there's no evidence that the board was biased or there was some irregularity with the hearing, and there was no objection to that, and that was clearly stated on the record at the beginning of the hearing. No objection. So, but I won't repeat everything that Ms. Huffman said, but I think she did an excellent job of summarizing what the proceeding is about, and that's a review of the procedure. We think the procedure is proper. Certainly nothing's been stated to reverse or say that the procedure was error or these folks didn't have an opportunity, full and fair opportunity to present their evidence. And the idea of re-arguing the facts and bringing up facts and saying that they didn't evaluate the facts or they should have reached a different conclusion, or, this is not about whether we necessarily agree with the decision, whether it was a good decision or bad decision. That's fully up to the board. That's their purview. That's their commission and charge. And we would respectfully contend that there's simply no basis to reverse that 6-1 decision. For the record, I would object to some of the items I don't think were in the record. I won't go through the PowerPoint. I don't think it really makes a difference to the argument I'm making, but there were some things in there that I don't think were in the record, including that last page of the report. And if I'm mistaken about that, I just don't remember seeing that in there. Mr. Romero's here. If the board has any questions about those concessions and design changes that were made, to the extent the board wants to hear of the first hearing to the second hearing, and there were significant changes. Rob, if you could just summarize those. Nothing new, no new evidence, just a summary of the changes that were made from April to June.
Yeah, we did. I'm Rob Romero. I'm the architect. I was actually, just for a little background, I was on the HPC for 10 years, and I was chair for 5 years. So I came to this project with a little bit of knowing how to do these kind of things. And those design cues I took from the house to try to pull the scale and some of the details, the windows. Some of the images weren't quite accurate because I intentionally removed the trees from my renderings to show the building, not the actual trees that we will propose. And we are intentionally trying to protect those trees where we can. And the design was approved, as you know. So if there's anything else I can do to answer, I'm here to.
Thank you.
I just had a question, not that we're really here to discuss design, but in our packet, I don't see there was a revised design of the garage.
The original
It went from a
garage was
two-story.
two-stories.
Yeah, it went from a
It's in
two-story to
the-
one-story. I didn't see the one-story. Sorry, either I missed it or, oh, I see the one-story now. Okay. I mean, I, think certainly the two-story garage design was way out of scale for the property. Just, as an aside, I'm not quite sure why that was proposed in the first place, but anyway, we're not really here to discuss the design itself, but the impact of it and the decision that the HPC made.
Thank you.
Yeah, thank you, Mr. Chairman.
Board discussion? I believe that the Historic Preservation Commission acted appropriately. I know Ms. Blomberg is very passionate about the trees, but the tree report was entered, but there was no one available for cross-examination. The demise of the trees is speculation, and they don't propose taking down the trees. Again, the demise of the trees is speculative from the report. The HPC did vote 6-1 to grant a certificate of appropriateness.
Yeah, I agree. And we have to follow the 4 findings of fact. And
well, we're here. It's did they ensure constitutional rights, including procedural due process? Well, I think everyone had due process, and ensure the HPC did not exceed its statutory authority, which certificate of appropriateness certainly does not. Procedural rules were followed, yes. Ensure the HPC did not commit an error of law. To ensure the HPC's decision was supported by competent material and substantial evidence, and I think they did consider everything and admitted the tree report, even though it was not prepared, was not available for examination, and to ensure that the HPC's decision was not arbitrary or capricious. I understand that Ms. Blomberg's very passionate, but I do think the HPC acted appropriately in granting the certificate of appropriateness, and it did pass 6-1. So.
I mean, I think Ms. Baldwin made some good arguments about the fact that they may not have fully considered the Wilmington Design Standards, the Secretary of Interior standards when it comes to the impact of the project on the adjacent properties. I don't know if that's really something that we can base our decision on.
If they didn't follow the design guidelines, or if they didn't consider and apply them properly, that would be considered an error of law, just so you know.
Okay. We're not really here to rule on this design, but I think the Secretaries of Interior standards and the Wilmington Design Standards are there to try to protect the historic fabric downtown. To me, this project is out of scale with the surrounding properties. I mean, you're looking at covering a significant amount of land behind these homes with concrete and structures, which to me seems incongruous with the other properties around it. To me, I'm not sure that they really followed the design standards very well, or the Secretary of Interior standards in regards to this project.
But, Mr. Chair, just confirming, unfortunately, we're not here to talk about design standards, correct?
Well, what I'm saying is that I think that's something that they erred in their consideration of this project, that they didn't really follow the Wilmington Design Standards or the Secretary of Interior standards in assessing this, the scale and also the impact of the project on the other properties.
Marks is saying really that not considering the Secretary of Interior,
I understand. I got you.
may have committed an error of law.
Understood.
Is one of the 6 factors that we can consider. Dolores, is that correct?
That's correct.
thing that I'll say about that is that lot was recently purchased, from what I understand, and if someone was to build a house on that lot, it would be the same proportion as what the current lots are.
And just confirming, there's nobody here from 407 or 409 speaking against it.
This is based on the record.
Do we open the public?
It's based on the record.
Thank you.
Okay, there's no comments from the public. I mean, my recommendation would be to remand it back to the HPC to consider this further. I think there's some things that they didn't consider in their decision-making that I think impact the adjacent properties.
I would, I'm prepared to deny the appeal.
Yes.
I think there was a reference to the owner of 407. My client, Mr. Beard, he owns 407 in the form of an entity. And I think if I could pull that map back up, I could show you if that has any impact on the discussion. But Cottage House LLC, my client owns that entity, and so certainly he's 100% in favor of the project. And if you can look and see where that is in proximity to the property, he acquired
Is that part of the record, Attorney Nichols?
No, I think it's relevant, though.
Well, we can't bring any new evidence in. I mean,
Well, on behalf, I would just say, to the extent, on behalf of the owner of 407 2nd Street, he's the owner of that, and he's obviously 100% in favor of the project.
thank you. Do we have any more board discussion or a motion before the board?
I'm prepared to deny. I'll make a motion to deny the appeal.
To allow the certificate of appropriateness to stand?
Correct.
We have a motion confirming the Historic Preservation Commission's certificate of appropriateness. Do we have a second?
I think she has some rebuttal before y'all make a decision. She's come to me to ask for that.
Okay.
That's the recording mic right there. What is it? Oh, she wants me to look at it. Was this in the record, or this is after?
Laura, if it's not part of the record, we cannot consider it. And there's a motion on the floor.
Okay, the hearing was... in June. No, it's not part of the record. But this is in September.
I think we have
Oh, no. No,
Dolores?
he can't testify. A neighbor had sent something to
Well,
her,
that,
but,
to me, would be new evidence, and we have a
Correct.
motion before the
Okay.
board to
So-
uphold the Historic Preservation Commission certificate of appropriateness, and we have a second. That's okay. Thank you. We have a motion and a second. All in favor of upholding the Historic Preservation Commission certificate of appropriateness, say aye. Aye. Opposed?
No.
Have 4 to 1.
is that 4 to 1?
4 to 1.
Motion passes.
Motion passes. All right. Scott, I know you need to leave. Jeff, I'm gonna ask you to come back up. And Graham, I think we'll go ahead and hear 112 Colonial, which I know you need to recuse yourself of. But in fairness to 112 Colonial, it will now have to be a unanimous board decision since we're down to 4 members. Is that correct?
Yes, sir, that's correct. I was just looking to see if the applicant was present to weigh in on whether they want to continue knowing that they would have to have a unanimous decision.
Are you okay knowing that you have to have a unanimous decision now with, us? Okay. Okay. The next item before the board today is item 9, which is 112 Colonial Drive, variance to the minimum rear setback for a detached single-family dwelling. You can proceed when ready. Welcome back, Jeff.
Thank you, Mr. Chairman. This is a request for a variance at 112 Colonial Drive. This case does have history for the Board of Adjustment. Due to the board not having a full complement of the board, the applicant asked to continue their case from August 21st, 2022 to today, September 15th, 2022. On July 6th, 2022, planning staff accepted an application for a variance to the minimum rear setback for a detached single-dwelling unit in the R15 residential district pursuant to City Code Chapter 18, Land Development Code Section 18-28. Subject property contains an existing single-dwelling unit and an accessory building. The applicant added approximately 462 square feet of living space to the single-dwelling unit in 2017, bringing the total heated floor area of the house to 3,042 square feet. The applicant has proposed a new 450 square foot addition to the existing single dwelling unit, which requires a 25-foot setback from the rear property line. The applicant has requested a variance to Land Development Code Section 18-28, which requires a minimum rear setback of 25 feet and has proposed a rear setback of 15 feet, a variance of 10 feet. The applicant states they plan to build a one-bedroom addition to the first floor of their existing structure so their parents may move in due to health needs. This matter is set for hearing for the Board of Adjustment today, September 15th, 2022. This case is subject to the 4 findings of fact, which I have put up on the screen for you. I'm available for any questions, and then the applicant is here as well.
Thank you. Any questions for staff? Thank you. Applicant, you are up if you have anything to say or add. Okay. I'm going to open it up for public hearing. Is there anyone here to speak in favor of or opposed to the requested variance? We'll close the public hearing and open up for board discussion. Well, I went by there and it's on the side where the driveway is, and it's not really going to be visible or impose on any of the neighbors, in my opinion. So I'm really okay with the requested variance.
I would agree.
I guess my only question is, could it have been moved closer to the structure, to the main structure? Looks like it's pushed pretty far back.
There's a concrete pad there. I think that's what that shows.
Right.
Could you come forward? If you looked at moving the structure forward a little bit closer to the home?
No, the concrete pad is an addition that I put on that was approved by the city last.
So it's actually a structure?
Yeah,
Gotcha,
I'm
okay.
just abutting it.
So that's actually.
So you're connecting the two?
Yes, sir.
Okay. Thank you.
I guess my only concern is it's a pretty significant variance. Setback variance. What kind of precedent does that set?
That was my concern also, but what gets me over that is the positioning of where the placement of this house is on this lot, and I think it is irregular the way it's set back, I mean, and also the diagonal part of it. I don't like to, like I said, I sort of oppose going away from basic standards, but I do see a difference just because of the shape and the positioning where this house is.
Well, and when I looked at the home, following down the driveway where the addition is, and then behind that, the new bedroom is really the logical place to put it. And that's why I'm really okay with it. I mean, it's the logical place to put it, and it can't be brought forward because there's a structure there. Actually, I think the two will be connected.
If you're okay, based on, or would you like to entertain?
Propose a motion.
Yeah, I will entertain a motion, I'll make a motion for approval of the item number 9 revolving 112 Colonial Drive. Approve the variance.
We have a motion before the board to approve the variance request at 112 Colonial Drive based on the 4 findings of fact. Do we have a second?
I'll second.
We have a motion and a second. All in favor?
Aye.
Aye. Opposed? Variance passes. Thank you, sir. I hate to do this to everybody, but I'm going to need to take about a 5-minute recess. Graham, you are welcome to come back.
So what are you're recusing yourself again, or you have to leave? We're on this end now. Oh, okay. Oh, really? Yeah, that's why I'm getting ready to list your Oh, really? How come the other people that weren't opposed to it, why didn't they be a party to the? Yeah. Well, that's what I figured. There are other people that are.
Can I ask a very general question? Are we really going to get this?
Is everyone back? I'd like to call the Board of Adjustment meeting back to order, please. Our next order of business is item 11, 1823 Carolina Beach Road. Appeal of zoning officer determination that trucks are being parked in the city right-of-way in violation of the zoning permit.
Good afternoon. Yes, this is an appeal of staff's determination that the property at 1823 Carolina Beach Road is operating in violation of city code. This property has a long history of nonconformities, including auto sales, use of the property behind by, this is a prior tenant in there, but 519, which is residentially zoned for parking automotive vehicles waiting for repair. The portion of the property that fronts on Carolina Beach Road is zoned commercial services. And it currently contains a vehicle sales use and also got approval to lease U-Hauls from the site. As part of that approval, Officer Barham noted that no U-Hauls were to be parked on the street, and subsequently we received complaints that they were being parked on the street routinely and issued a notice of violation on June 10th, 2022. The applicant appealed that notice of violation, was advised that should the board disagree that they are in violation of their zoning compliance form, or permit rather, that there are other city code sections that disallow the use of the public right-of-way for commercial enterprises, and other departments, including the police department and engineering, may still enforce their requirements for no commercial activity on city streets. I believe that the applicant, the applicant is Attorney Kerner. We do not have an agent form on file, but I believe that the property owner may be present to introduce Mr. Kerner as his attorney, and we can get an after-the-fact agent form on file.
Okay, thank you. Any questions for staff? Thank you.
I'd like to submit the city's case summary and all attachments into the record, please. Thank you.
Thank you. And the applicant is present?
Good afternoon, Mr. Chairman, members of the board. My name's Tom Kerner. I'm an attorney here in Wilmington, and I'm here on behalf of the appellants who are the heirs of Leroy Coombs, which is the property owner of 1823 Carolina Beach Road, as well as Frontline Used Cars, LLC. They're the tenant, and this matter arose when Mr. Frankie Bordeaux, who's also present, he's the owner of Frontline Used Cars. He sought permission from the city to operate a used car and vehicle leasing business from the subject property. In February of 2022, he received a zoning verification form from the city stating that it was a permitted use at that location. And in March of 2022, another identical zoning verification form was issued again, reaffirming that the use was permitted. The previous tenant has no connection to Frontline Used Cars LLC. There's no identity of ownership. It's not a continuation of any prior business, and so we disagree with any characterization or reference to any prior owners. However, we would note that the previous tenant did also run a U-Haul business from the same property for some time. And in fact, Mr. Bordeaux's operation of the U-Haul business is done exactly the same way that the prior tenants was, including parking the vehicles on the street. So when, I'm sorry?
We'll have time for public, we'll have time for public comment. Thank you.
And I can have him, I can have Ms. Beck testify to that if we need to, but his belief was that this was how it worked. And sometime after that second zoning verification form was issued, the city contacted Mr. Bordeaux, and they didn't notify him of any problems or issues with his use of the property. They only told him that he needed to get a zoning compliance, he needed to get a change of use permit. They didn't say what the change of use was. In his mind, it was an existing use, but he went ahead and filled it out anyway, just so that he wouldn't have any problems. So at that time, the city, if they had an issue with the vehicles on the streets, they could have alerted him to it and explained to him that he needed to ask for a change of use, but they said nothing. They approved the change of use. He added that he's running a U-Haul business on his application, and that seemed to be the end of the story. I also want to add that Mr. Bordeaux is a former member of the Board of Adjustment for Nash County. He was on the Board of Adjustment up there for 8 years, so he's not here contending that he should have a special right to violate any laws or to flout the rules or anything like that. He believed that when he got this permission that he was in the right as far as his operation of the property. At the time, the change of use permit was granted. The city sent him back the document that you'll see in the city's packet. I believe that's pages 21 and 22 of their packet. And at the top of page 1, there's a handwritten notation that says, "See attached information sheet." And the attached information sheet, the third page, just lists some items on there, and I believe the one that the city is most complaining about now is that you cannot park vehicles on the street. Mr. Bordeaux looked at that and saw that it says attached information sheet for 1823 Carolina Beach Road. He took a look at the property and said, yeah, well, you can't park on Carolina Beach Road. That makes sense. He did not take it to mean all streets or any streets, and so parking the vehicles along 519 South Carolina Avenue and adjacent to 1823 Carolina Beach Road did not seem to be in violation of this. And I would submit that the city could have done better here explaining that these were, as it now contends, express conditions on the use. It just says it's an information sheet. It doesn't clarify where you can and can't park, and it's a reasonable assumption that because the information sheet only references 1823 Carolina Beach Road at the top, that that was the street that was being referred to at that point. So the city came along and they did photograph some of his U-Haul trucks parked along the side of the South Carolina Avenue. And we have been advised by the city since this notice of violation came out that there may be other sections of the code that this violates, to which we reply, well, that's fine. Are we to take this as a notice of violation of those sections? Could we see what the city's position is on those? We have not gotten that yet. So what we're responding to today is simply the notice of violation that pertains to the change of use that he submitted to the city. And the question is simply, how is this providing adequate notice that these are express conditions? How is it providing adequate notice that you cannot park a vehicle on South Carolina Avenue? Again, I would ask, we're not asking to overrule or make findings that it's okay to park vehicles on the city street. That's not the subject at this time. It may be the subject of a future hearing. But the question is, on these circumstances, the way that the information sheet is written, is that clear enough notice that this is an express condition that you cannot park vehicles along South Carolina Avenue? And again, bear in mind that Mr. Bordeaux was an 8-year member of a Board of Adjustment in another county, so he's got some familiarity with these things. He's owned 7 different businesses. He's not a troublemaker. And like I said at the beginning, he's not here to ignore the laws or the rules, but the problem that arose with this is that it was not clear at the time that the permit was issued that South Carolina Avenue was off limits to him parking. And had he understood that, had that been made clear, he would have taken a different track with his business, but now he's committed. He's got inventory, he's got people working there, and he's in a bit of a bind because he can't use the property. If the city prevails, he can't use the property for the purpose that he was previously approved for. So that's all I have by way of argument. If you have any questions, I'll be happy to answer.
Any questions? No? Thank you. Is there anyone here to speak in favor of or opposed to the proposed variance request? Please come forward. And if you would, state your name and address, please.
I apologize for the outburst earlier. I've never done anything like this before. My name's Ashley Spalding. I live at 601 South Carolina Avenue. My husband and I own that property. We're on the corner of Elm and South Carolina. As you're aware, the subject property of this appeal is a corner lot on Carolina Beach Road, South Carolina Avenue, currently in use as a car sales lot and U-Haul rental outlet. I believe all residents would have no problem with either business except for the issue of on-street parking of numerous oversized trucks and the fact that the hydrant is blocked on this corner 24 hours per day. South Carolina Avenue, east of Carolina Beach Road, is a residential street that ends at West Lakeshore Drive at Greenfield Lake. There is concern with the parking of so many large vehicles along the northern side of the residential street. There have been as many as 8 large trucks there at one time, as you can see from the exhibit photos. They are intrusive to the neighborhood and also pose a significant safety hazard to vehicle traffic and fire safety. With the refurbishment of the Greenfield Lake Amphitheater creating traffic several nights a week and the large increase of traffic on Carolina Beach Road, getting on and off of our street is beginning to become more and more difficult. The obstruction of the roadway where these trucks are parked makes it especially difficult to turn off and onto Carolina Beach Road that also has a busy sidewalk. I have read the statement of the appellant and supporting documents. The appellant readily admits that, of course, they would not park on Carolina Beach Road, yet seems to think that parking on South Carolina Avenue would be justified. Of either, Carolina Beach Road would cause less of a danger. They also referenced that they were surprised that they would be restricted from South Carolina Avenue adjacent to a CS zoned property. In fact, they regularly and continually park the vehicles all the way down South Carolina Avenue to Elm Street, which is clearly zoned R5, and they make no mention of the fact that the vehicles are grossly oversized from the limits outlined in Section 557. I would draw your attention to the exhibits. These are all, y'all are supposed to have, do y'all not have these? Y'all have these, okay. Accompanying this letter for a better understanding of my perspective of the issue at hand. Given that these trucks are continually parked down South Carolina Avenue well into the R5 zoning section, that they are grossly oversized, even if they were parked in a legal position, that they impede safe traffic flow and cause an extreme fire danger. I would request that this appeal be denied and that this truck parking be prohibited as agreed to by the operators in the March 2022 change of use decision. And then I have all the different statutes and codes that they're breaking. Should I go over that?
You can ask that they be admitted to evidence, is that correct? Yes.
Okay, can this please be? Huh? Yeah, I have plenty of copies, yeah. And I have pictures as well. And my biggest concern is this right here. If my house were to catch on fire, how would we put it out? We couldn't, because they have to have access to the front of that hydrant. And it's 15 feet from a hydrant, and this is 24 hours a day. Thank you.
Thank you.
Thank you.
Ma'am,
Yes,
you'll
ma'am.
need
You
to go to the front and speak into the microphone, please. Could you provide your name and address?
Do you want that too, or no? That's just my butchered copy. Okay, this will be helpful for the clerk. Okay.
My name is Rebecca Taylor. I live at 602 South Carolina, the house across the street from Ashley's. I've lived there for 25 years. We have seen businesses come and we have seen businesses go. And we have generally not objected, even when there were some questionable things happening. The lawyer before said that there was a U-Haul business operated there before, and there was. He never, ever parked in the street. They parked the U-Hauls on the lot, and they kept all of the vehicles on the lot. So this is the first time we've had to deal with big, oversized, wide trucks parked all up and down the street. They have, and I think you have a picture of actually double parking on both the south and the north side. That is not all the time, but those 6 to 8 trucks, which block all the way to the stop sign at Elm and all the way to right at the edge of Carolina Beach Road much of the time, are there basically all the time.
Thank you. Yes, ma'am.
My name is Gail Carasy. I also live at 602 South Carolina Avenue. We have lived there since 1997, so we're pretty aware what went on in that block. My major concern is, with those trucks all parked there, I have been going to turn onto Carolina Beach Road. Another car comes to turn onto South Carolina, and I was almost hit. Another time, I was coming home, which again would have been past those trucks, and they were all the way out to Elm. Somebody came from Elm and almost hit me. So you just cannot have those trucks on our street. Thank you.
Thank you.
Chairman, Board, my name is Frankie Bordeaux. I too am a native of Wilmington, North Carolina. I am the owner of Frontline Used Cars and Leasing. I cannot and will not dispute what any of these ladies or gentlemen have said. We don't control if you, the customer, is dropping a truck off and we're closed. She's absolutely right. I didn't like it. We've had one complaint that's on record from the police department, and they were right to do that because customers park trucks on both sides of the street. As we recognize it, we got to move immediately. They want to speak of fire hydrants. Occasionally, yes, they're correct. Fire hydrant's been blocked. That's not a 24/7. That's what they want you to believe because they want the trucks gone. That's not 24/7. We've been there 6.5, almost 7 months. Ask them to show you pictures, evidence of that 24/7. Those trucks come and go, depending on the season, every 3, 4, 5 hours. If you look at the pictures and look at the numbers of the trucks, you won't see the same truck being in the same location not more than once because they don't stay around long with us. From a safety perspective, if you're turning off of Carolina Beach Road onto South Carolina Avenue with the traffic, it doesn't matter what time of day it is, with the way the traffic comes in there, I'm subject to get hit. Why is that? Because when you turn from Carolina Beach Road headed to the south on the South Carolina Avenue, you're rushing to get out of the way of the vehicles coming at you full speed. So you cut short. That's a natural instinct. The area itself, since we've been there, has been kept up. The city's contention is we are the same as the people that were there. Well, there's one thing that's the same. That gentleman was black and I'm black. That's the only thing that's the same. I talked to John twice. John stipulated that the garage that you see in the back of the picture that's not a part of 1823, that we couldn't have any bearings or anything to do with that garage from day one. Totally in compliance. I'm not here as a bad guy. I'm here as a business guy. I'm here as a native of this city, and I own and live in this city. So I beg you to not side with the city from the perspective of what we can or cannot do from the parking of these trucks. Now, if there had to be an out, then why isn't the city up here telling you or giving you examples of what we could do to have a happy medium? You're not getting that. We will welcome it. We were told we'd get something. We haven't received it. I personally have not received anything. But I can say to you from a safety perspective, from a cleaning perspective, from a noise perspective, from an ordinance perspective, we have been in order from day one. This is not my first ownership. This is only one of 2 places that I own in the city, and we have no issues. I will say to you that as an owner, we'd like to do business in a business-friendly area. If we don't have trucks to do our business with, which our trucks are set up on what's called 24/7. If you want a U-Haul right now, we're closed, you can come pick it up. So again, they don't stay around long. There's not room enough on the lot for both U-Haul trucks, trailers, and used cars. There's not. So I throw myself at the mercy of the Board of Adjustment to say, give us an out to do our best to do business for the citizens of the city of Wilmington. And we'll do our best to be outstanding citizens as we've always been. Thank you.
is it, since he is the applicant, I mean, is it okay to ask him a question during this session, or should we do it? Okay. Sir, could you?
Yes, sir.
The trucks that are parked on the street, how much do they weigh?
Me, honestly, I don't know. But again, from a requirement perspective, I'm giving you an honest answer. From a requirement perspective, we have what's called 10-footers, then we have 15-footers. I don't know personally what the gross weight is. I can go on my phone, look it up, and tell you exactly.
And I just did that, and it says they're 8,000 pounds. I just was asking, and I'm an officer.
Yeah, I honestly don't know.
I was asking you, since it's your business and your profession, if you knew
Yep,
those things.
I could not tell you the honest answer as to what the weight is, but I do think the 26-footers are the largest ones that we've had the most complaints about.
Okay, that was just my question on weight.
Okay.
Mr. Hovas, if I may just jump in, I would like to say that I received an email earlier this week from a neighboring property owner who expressed that they were unable to attend today because of some medical issues, and the family has COVID, and that's in this letter that they would like to present to the board. And in this letter, it does have the dimensions and the weight rating for U-Hauls, if that is of interest to you.
Well, yes, please. We'll allow.
Ma'am, have a seat. We have copies of that. We'll
Quick
get it to
question
them.
for you.
Thank you.
Yes, sir. So you said that your clients are parking the trucks there. You guys, your team is not parking the trucks there?
That's in the evening once we leave. If our lot is full, we've had instances where, which is on one of the pictures she showed, which recently happened about a week ago, where we had clients that pulled trucks on, we generally park trucks on the left, when I say left side, if you're going up South Carolina or going down, then we generally will park trucks from about 20 feet back all the way to about 15, 20 feet within the fire hydrant. And we'll do it on the left side. Thank you. And on the right, we came in that morning and they had 3 or 4 trucks with the trailer parked on the other side. Again, that's inappropriate, but that wasn't something that we could actually control as a business from those people that dropped them off.
I'm looking at the pictures, and I mean, that's a lot of U-Hauls on the road, and I don't see how there would be that many client drop-offs during the day. And if this is a regular thing, that would be really difficult to deal with if I was a resident in that area.
I'm sorry, I'm not hearing everything you're saying.
I said it looks like there are, like in this one picture, there are 6 or 5 U-Hauls parked on the side of the road, and I don't know how clients would have organized these parked all in the same way.
No, okay, that's what I just said to you. We do, if you're going down South Carolina, we generally park those over on the side you're talking about.
Okay.
But in the other picture where you see 2 or 3s on the right side going down, we did not do that. That we had to then move those, and we moved the majority of those into the lot that you see where the cars and the buildings are.
Do you know of any other U-Haul stores that are parking on the streets? Because I was born and raised here, and I've never seen that before.
Well, if you are at the corner of 3rd and Right, it happens routinely, but not just with U-Hauls. They also have a wrecker because you have a call out across the street from Pinnacle, and that street is done that way. That's on a routine basis. Okay, some days are better than others, and some days are worse. If you're on Jacksonville, I think it's Street, going out Market, if you make a right, it's worse because the narrowness of the road or the street, as where we are, at least the street itself is extra wide. It's not a normal city street in terms of the width of it. So if you going out Carolina Beach Road, and I don't know the crossroad, but the company is John's Used Tires. If you look to the right, John's Used Tires on the right, 26-footer stay there 24/7. So I'm not advocating to be able to leave trucks on the street. I'm advocating to be able to do business. their alternatives, there's a lot in the back of 1823 that we were told we can't park anything in there, and we haven't. In fact, we chained the fence up so nobody would pull in there. But again, there are alternatives, and we're standing here today speaking of what I would say is based on what the people did before me and the issues the people before me had. Now, yes, we have trucks on the street. We're not the only one, and we're not the last one or the first one to do that. There have been 2 or 3 other, in the last 15 years, there have been 2 or 3 other U-Haul dealerships right there, same location. Now, I haven't done a record check to see what violations have been garnished towards them. But if you do a record check to see what violations have been garnished towards me, it's been 1. It's the one we're standing here dealing with today. So if there's an out, there should be an out for everyone, not just for the city or not just for Frankie, but for everyone that's applicable.
Thank you.
Any other questions?
No, I mean, I agree with you there. The code should be enforced equally amongst everyone, and that's certainly a code enforcement issue that needs to be addressed. I just, I think perhaps you're trying to do too much on that lot. I mean, you're trying to run a business there, but the business is U-Haul, and you've got some other businesses there, but you may have too many things going on there. I think you should provide space for them to be able to pull the trucks in after hours to get them off the street. I think it is a safety hazard to have those trucks parked along the street, whether it's your fault or not. It's the clients maybe bringing them in after hours. But if you had a spot for them on the lot, if you provided that option for them, then they maybe could pull it onto the lot. But the ordinance is pretty clear. You're not allowed to store vehicles on the streets like that, and may or may not be your fault. Maybe the people that are bringing them in are doing it, and then they get left there for long periods of time. But it looks like a considerable safety issue that obviously the city's concerned with, and we're concerned with, the neighbors are concerned with it. You have to follow the requirements that the city has for business use, and right now it seems like it's not really being followed in the fact that these vehicles are being parked on the street where they're not supposed to be. That's just what I see. I think I agree with you. Code should be enforced equally. If other businesses are doing the same thing, then obviously they need to be enforced.
Just wanted to make one point.
Could you speak in the microphone, please? Thank you.
Pardon me. I just wanted to get back to our original point, though, that we're not, the issue, a lot of testimonies come in about these other things, and we hear what you're saying. There may be other sections that there's a violation of. We're not asking today for some sort of exemption, but those other possible violations are not under consideration today. I know people have talked about them. It's in people's minds. But the violation, the notice of violation, yes, there could be a new notice of violation issued. Great. When that comes out, we'll address that at that time. You've heard what he has to say. No one's claiming that the use isn't occurring. What we're just saying is that the permit did not put him on notice. If you look at that information sheet, as they call it, is that clear enough to direct a tenant not to park vehicles on South Carolina Avenue? It refers at the top to Carolina Beach Road, and then it says no parking in the street. Had it said, do not park a vehicle on South Carolina Avenue, and that is an express condition of this permit, and if you violate that express condition, we'll revoke your permit and we'll fine you. That would have been very clear. Just like the notice of violation letters now say, this is a final determination by the city, you have the right to appeal. In the past, a lot of counties didn't do that. There's a lot of case law on whether people had sufficient notice. So a lot of cities have adopted this practice that Wilmington, to its credit, follows now. They say, word for word in the notice of violation, that This is a final determination. You have the right to appeal. All I'm saying is that the same practice should apply at the time of issuing a permit. We wouldn't have this problem right now had the permit conditions clearly been identified as conditions, and had they said, do not park on South Carolina Avenue, we wouldn't have this issue here. We might have another issue in the future, but again, that's outside the scope of what the notice of violation contains, and we're limited here to our consideration of only the items in that NOV, not things that might come up in a future notice.
Thank you.
Thank you.
Is there anyone else here to speak in favor of or opposed to? Yes, ma'am?
From what I'm understanding, he is
State your name and
claiming.
Can you state
Oh.
your name and address again, please? Thank you.
Ashley Spalding, 601 South Carolina Avenue. He's stating that South Carolina Avenue is not a street. If he didn't understand that do not park on the street meant do not park on South Carolina Avenue, right? Because the ordinance just reads do not park on the street. I saw what it said. So that means in his mind, South Carolina Avenue is not a street. And it is a city street. We pay taxes on it and we drive on it.
Thank you.
I just wanted to make that point.
Thank you.
And staff would also like to reserve the right to rebut once everyone from the public has finished speaking.
Yes, ma'am.
The owner stated that they are just there and then they move them. I counted from last Friday to today, there have been 7 vehicles on that street continually. I can't tell you they weren't the same vehicles, but there are vehicles there the whole time.
Thank you.
Thank you.
Staff, please.
I would just like to state that to the extent that the zoning permit is unclear in providing sufficient notice, which I believe that stating that it's not allowed to park in the street without any specificity as to which street, because that is any street within the city, not even necessarily ones adjacent to that site. But at any rate, if staff was not clear enough in providing that notice, I'd like to point out that the other code provisions with which the applicant may be in violation are enforced by the police department and engineering, and those code sections do not allow for the courtesy necessarily of a 30-day notice of the violation to allow the applicant to come into compliance. If the police department goes out there to clear the right-of-way, they can have the trucks towed. So since we did send the notice of violation, because we do believe this is a violation of the zoning ordinance, since the business is not being conducted on site and it's not being conducted in accordance with the zoning permit, we did give the applicant the opportunity to present their case to the Board of Adjustment, and it was our preference, and we discussed this with the applicant in advance of the hearing, but that they would just come into compliance prior to the hearing and hopefully save everyone the time and the trouble and go ahead and address the safety issue as rapidly as possible. I will also say, as far as enforcement of this site versus other U-Haul sites, I'm not aware of another U-Haul site where trucks are parked in the street. I drive by this site almost Monday through Friday, and it's only been recently that I have noticed the U-Hauls being parked in the street. And I mean, Mr. Bordeaux noted that whenever he came in for the zoning compliance, the zoning permit, that, we noted that it was a lot to put on one site, and he did agree that both uses could fit. He spoke to Officer Barham about that, who is here to talk about the discussions that they've had. If you think that there's some value to his testimony, and there I'm sure is value to the testimony, if you should like to hear it. And the prior U-Haul use there, I recall the applicant very well. Ms. Bernice Johnson was involved in that project, and the U-Hauls were parked on the site during her operation of that use. So that's all I wanted to address, but I'm happy to answer any questions that you may have of staff.
One quick question I've got. I'm reading the attached information sheet, and to me, cannot park vehicles on the street is fairly clear. Also, there's no parking allowed on Carolina Beach Road. So as a matter of course, the U-Hauls cannot be parked on Carolina Beach Road in front of his lot because they would block the right lane of traffic. So to me, I think vehicles cannot be parked on the street means South Carolina Avenue. So. Any further questions for staff? That wasn't a question, sorry. Thank you.
Thank you.
Anyone else here to speak in favor of or opposed to? I'll close the public hearing, open it for board discussion. I drove out there Sunday, and the U-Hauls were parked down to Elm and in front of the fire hydrant. And as I was turning around, there was a gentleman trying to get out of Elm, and he was having the most difficult time because he couldn't see around the truck. There is no parking allowed on Carolina Beach Road, so the only, in my opinion, the only thing that can be inferred from cannot park vehicles on the street is South Carolina Avenue. So, I am 100% behind the city on this one.
Is that a motion?
I could make it a motion.
Actually, for further discussion, like it does outline that section, it applies to the land development code, section 18-177, and section 5-57 does fall within that code, and it does clearly state the size of vehicles that are not permitted, the weight of vehicles that are not permitted for less unloading and loading on streets. And like I said, I'm all about a business and being able to run it, but you can't run it at the safety of residents and other citizens and violate codes that are in there. If not clear, this will be just an example for us as a city to make it clearer. So, just my 2 cents.
Well, it was a motion, the variance motion was to allow on-street parking, is that right? Is that correct?
No, sir, this is an appeal of staff's determination.
Code determination. Then I'd like to make a motion to uphold the staff's determination that vehicles were being parked on South Carolina Avenue in violation of the permit.
I'll make a second to support that.
We have a motion and a second. All in favor?
Aye.
Aye. Opposed? City's determination is upheld. Thank you. The next item before us today is item 12, which is 4003 Park Avenue, variance to City Code Section 18200 to allow the conversion of a non-conforming accessory building.
This is a residentially zoned and developed lot. It's got a structure on it, a single-family residential structure that was built circa 1930, and an accessory building. In April of 2021, the applicant applied for zoning approval of an addition to the accessory building that is located to the rear. It may be difficult to see in this picture, but it's where my cursor is. They obtained a permit to put an addition onto that accessory building. It was set 5 feet off of the property line, as would be required for a new accessory building at that time, because the one that was existing did not comply with the setbacks. At some point since that was inspected by city zoning, it's been converted to an accessory dwelling unit, and it does not meet the city code requirements for that because current code requires that ADUs that are part of an existing accessory building be located in an accessory building that meets or exceeds the setbacks for the district, which that one does not because it had that non-conforming portion. On July 29th, planning staff accepted an application for a variance to allow the accessory building that was put in to remain after the fact, and that is set for hearing today. I'm happy to answer any questions that you may have of city staff. But generally, this is a site plan of the property that shows the rear of the house. It's only the rear of the principal structure. The shed that was already on site whenever the applicant purchased it, and then the workshop addition that was put in. And the applicant is here to give a brief presentation too, I believe.
Thank you. Any questions for staff?
I didn't even see this, I need to bring to the attention. I actually work for the applicant. I have a listing, and I didn't even come until I just saw the name on this. I should recuse myself just for that impact. I apologize. I usually check all of them, and I did not see this. That would cause them to come down to having to have unanimous for, and I do want to bring that up.
Okay, in fairness to the applicant, we would need a unanimous decision of the board now that we're down to 4. Are you okay to proceed under that scenario?
One of my clients, Josh Hodges, he had left. He was, so I think out of an abundance of caution, I would ask for a continuance, just because I haven't had a chance to talk to Josh about it. His wife, Adrian's here, but we were otherwise ready to proceed, but I guess out of an abundance of caution, having not talked to Josh, I would respectfully ask for a continuance so we could have
Understood.
5 members here.
There's been a request for continuance of 4003 Park Avenue to the October 20. Is that okay?
I'd move the continuance.
Yeah, and I apologize that I did not catch that.
Yeah, thank you.
We have a motion and a second. All in favor?
Aye.
Aye. Opposed? 4003 Park Avenue is continued to October 20. The next item, and appears to be final item before us today, is number 15, which is 6120 Oleander Drive, variance to open space requirements for a mixed-use development.
I think we still need to do Chairman Moore, if it pleases the board, item 13, the continuance request for 4003 Park Avenue, the appeal portion of that, could we continue that item to the November meeting of the Board of Adjustment, please?
Okay, so we're going to do, item 12 will be 1020, and then item 13 will be, what's the November date?
November 17th.
So I make a motion to continue item 12, 4003 Park Avenue to the October 20 meeting, and continue item 13, 4003 Park Avenue to the November 17 meeting.
I'd second.
All in favor?
Aye.
Aye.
And
Thank
Mr. Chairman, we were on number 14.
14, you're right.
14.
I'm jumping ahead.
We're almost there.
Almost. 1541 Eastwood Road.
All right, good afternoon. All right. On August 3rd, 2022, planning staff accepted an application for a variance to foundation planting requirements for a property in the Urban Mixed-Use Legacy District, Conditional District, pursuant to City Code Chapter 18, Land Development Code, Section 18322, Section 18490 of the previous Land Development Code. On July 17th, 2018, City Council approved a conditional rezoning from R15 Residential District and Special Highway Overlay District to UMX-CD, Urban Mixed Use Conditional District, for a large-scale mixed-use development, otherwise known as Centerpoint. On September 20th, 2020, City Council approved a modification to the conditional rezoning to increase the number of residential units and hotel rooms, decrease the overall retail and restaurant space, and adjust the site layout. Effective December 1st, 2021, the Urban Mixed-Use District classification was considered a legacy district per the new City of Wilmington Land Development Code, Section 18-102.
The project CenterPoint is vested under the previous land development code. Foundation plantings were required per Land Development Code Section 18490. Previous Land Development Code Section 18490 and current Land Development Code Section 18322, foundation plantings, states for all portions of buildings adjacent to parking lots and internal drive aisles, foundation plantings shall be required between the building wall and the parking or drive aisle curb. The area of the ground floor of the building face adjacent to the parking area or internal drive shall be multiplied by 12% to determine the minimum total area that shall be planted as foundation landscape areas. A variety of height and size of plantings shall be required. The applicant has requested a variance to Land Development Code Section 18322, Section 18490 of the previous Land Development Code, foundation plantings to remove required foundation plantings located at the front and side elevations of retail buildings facing parking lot areas, and to allow only foundation plantings at rear elevations facing parking areas. The applicant states that foundation plantings, particularly along the main pedestrian shopfront areas, inhibit the width of walking paths, disrupt pedestrian flow, and limit the use of exterior areas for pedestrian seating and activity. The applicant further states that the development is designed with the intent of creating an urban feel with walkable and pedestrian-friendly paths, pedestrian plazas, and intentionally placed seating and gathering areas. The applicant states that the goal of CenterPoint is to create a buffer via pedestrian light poles, seating, and intermittent planters placed on the sidewalk to reduce the impact of walkway width. The matter is set for hearing today, September 15th, 2022, before the Board of Adjustment. This case is subject to the 4 findings of fact up on the screen there. I would like to include this presentation and all materials into the record, and I'm available for any questions.
Thank you. Any questions for staff? Okay.
Thank you.
Is the applicant here? Thank you.
How are you doing? My name's Toby Hinkle. I'm with CI Design. I'm accompanied here today with our client, Alan McMahon of the Beach Company, and the civil engineers on the project, McKim and Creed, both with Catherine Espinoza and Emily MacArthur. For the most part, the summary kind of spells out what we're looking here for. CenterPoint, if I can get to, apologies. The intent behind the CenterPoint project is to adhere to the intent and respect what we feel the urban mixed zoning is trying to achieve. The intent's to have pedestrian-friendly areas that are walkable, places where it's not just about the vehicle. We've tried to downsize parking lots, we've increased some of the structured parking, and we've really tried to connect a lot of the pedestrian paths both internally to give multiple options, and externally on the side towards Eastwood, connecting to the multi-purpose path that the city has provided. It's really about the urban experience and the urban intent behind the code. We've got a project that offers multiple scales and sizes of buildings and uses, all meant to activate the public realm and really invigorate the pedestrian experience. One of the things we did a month or two ago, we went in front of the Design Adjustment Committee, and we're able to pass an adjustment to the curb design in the main plaza area that goes through the site, and that is not really good technical work. Again, to allow a multi-use outdoor space facility that could have farmers markets, food trucks, all the things that you would look for in a good community space, but also in a very active urban setting. The plantings themselves, as far as the foundation plantings, we find restrictive. They appeal more personally to a sort of a big box or large strip center, and that's not the feel we're trying to promote. And as far as is removal of them. We're not just looking to remove them outright. We're going back in, like was said, with decorative planted pots, large scale, to create that urban edge. We are relocating some trees, but we will still have trees and tree grates that are creating that buffer, but we want to add pedestrian poles, add benches to create that edge, which is what we see is the intent or the apparent intent of the foundation plantings. I don't know if any of my other team would care to speak, but if you have any questions, I'd be happy to answer them.
Thank you. Any questions? Okay, thank you.
Thank you.
Is there anyone here to speak in favor of or opposed to the proposed variance request? Thank you. We'll close the public hearing and open up for board discussion.
I mean, I've got the same concerns with these types of plantings on buildings like this. I don't think they make a lot of sense to put foundation plantings in front of buildings. To me, they just provide a maintenance issue. I think they should be pulled out closer to the parking edge or sidewalk edge and leave the space in between the building and the and the edge of the parking lot open. I don't understand, maybe that's appropriate in some cases, but I think in this case, it doesn't make much sense to have plantings right up against the building. You want to create a buffer to the parking lot, but I think it really needs to be more at the parking edge instead of right in front of the structure itself. And I think it provides a maintenance problem. It pushes water under the building. It creates all kinds of problems where pulling the planting away is really better. I mean, you really don't want to even put planting up against your house. It's same idea. It's just creates the building doesn't dry out because it's shaded by the plants and all kinds of other issues. I think you can provide that buffer and landscape character pulled out from the building and provide that buffer that you would like to have to sort of soften the impact of the hardscape.
I agree. I was reading through the development plan and pedestrian traffic and outdoor dining. Having plants right against the building really will impede pedestrian traffic and impede outdoor dining and restrict what's available for use. So in this instance, in urban planning, I do think foundation plantings really, I agree with you, should be moved away from the building. I mean, there shouldn't be any at the foundation. It should be, the landscape should be moved away closer to the parking lot.
Yeah. Question for staff, is this something that you're looking at, Catherine? Is this anything that staff is looking at as far as the requirement of putting plantings right up against the building?
This is something that made it into our December 1st code right of last year, so it was fairly recently looked at, and I'm not aware of any proposed amendments going forward that would address the landscaping around the building, but I see Brian looking at me like he wants to speak.
I am prepared to respond as well. I just want to point, just some clarification, the foundation plantings aren't required to be directly adjacent to the building. They could be anywhere between the building and the parking area. It doesn't matter. So they don't have to be up against the building like where this discussion is going.
All right, so there is flexibility. They're not required to be right at the foundation. Okay.
The amendment that went through last year, the previous code required foundation plantings based on the entire facade from the ground to the roof. The new code actually restricts it to 12% of the first floor only because, obviously on taller buildings, that would be a very excessive amount of foundation planting. So that was the adjustment that was made last December.
Mm-hmm.
And the foundation plantings are not against the building. They can be anywhere between
They can be anywhere between that parking and drive aisle and the building itself, anywhere in that area.
So I guess the question on this particular one is that they feel like the amount of plantings that they're required to provide is impeding use of that space in front of the shops?
That is my understanding. They want more flexibility with the use of that space for their activities that they have planned.
Right. Does the city support some flexibility in that so that we can, they can provide, outdoor space and dining and that sort of thing?
I think the city supports what we have on the books.
Is there options for, moving those plantings around to other areas to get the same percentage? But
they could be anywhere on that side of the facade. So anywhere from, if you have a facade facing a parking area, anywhere between either side of that facade, between the building and facade. So there's flexibility within that.
So can they be clustered?
They can absolutely be clustered.
Right. Okay. So they can leave spaces open and have clustered.
That is
to meet your requirements.
Yeah, come forward.
What we're proposing as far as the variance is more of an alternative to the foundation plantings themselves, with the use of large pot plantings as those buffers. The question, the concern that we have with the 12% when you're looking at some of these areas and these spaces is it's not really creating, it cuts off a considerable amount across some of these smaller buildings or shorter buildings that narrows the pedestrian way. And we've got cross connections that it would be helpful if we had a little bit more, it would be helpful from a pedestrian experience, in our opinion, if those could be something other than necessarily plantings, if the purpose of the foundation plantings is to create a buffer and an edge between the building and the parking lot, which is what we feel the text is, the intent of the text is. So we're not, I apologize for the confusion on the location as far as the foundation plantings. We're not saying we don't want anything as a buffer. We're suggesting that the light poles, the benches, the above ground potted plantings serve the purpose of those foundation plantings.
How many foundation plantings are you supposed to have according to city ordinance?
The calculation is based on the face of the building that is facing and fronting the parking lot. So if you take the square footage of that area, be it 60 feet long by 20 feet high in some cases, you take 12% of that, and that's the area of plantings that you have to have in your sidewalk between the building and the parking lot. Our purpose in this, or our perspective in this, is that determination doesn't allow a lot of flexibility between tuck it into places where between buildings we might be able to have more plantings and such and get that benefit while still maintaining the retail and street front feel that you would have. Yes, it's a parking lot, but the UMX zoning is intended to be an urban mixed environment, not necessarily a suburban shop front.
Brian, so you're saying that they could cluster stuff. Can they do it between buildings, or it just has to be along that? It has to be somewhere along that facade that you can cluster them, or you can't put them between buildings. Is that?
It would need to be along that facade, between that facade and the adjacent parking area or drive aisle.
And they're proposing to utilize various medium, not just the plantings, having the pots and different types of things to provide that type of diversion from the parking. Like, I mean, I see that it's actually a good way of changing it up, because then you have the versatility and the flexibility of changing those spaces with movable pot items where it's like, but.
I think with the movable pots, staff concern is they can be moved, and then they would no longer be in compliance with the code. So we generally don't allow those. Well, I mean, we don't generally, we just don't allow those because they can be removed, and then they will be non-compliant.
Yeah. No, I
And
get that.
the idea of the foundation landscaping in our mind is to kind of soften that edge between the building and parking, because it is a kind of a drastic change between where you're parking cars and where you want people to enter your building.
Okay.
So obviously, they could do a fixed planter structure.
Anything that's not movable would be permitted.
The way we're looking at those planters is they won't, especially along the parking lot areas, they won't be movable. We're going to fill these things with soil. They're most likely going to have some drip irrigation that's piped to them, potentially. So the intent isn't to be able to move the ones that we're looking to remove. Really, anything that might be flexible is along the Center Point Drive roadway where we've got the flush curb that we were able to pass. I'm sorry, I don't have a mouse that I can point to, but those, because of an event, might move and could be moved because they're not part of the same requirement. The planters along the planters that were proposed, the foundation plantings that we're trying to remove along the parking areas will have pots that will be permanent for the most part, as far as being placed there, having, with no intent to move them.
How close to the 12% requirement can you get with the pots?
Probably, I can't commit to the exact numbers,
Well, I understand.
but maybe a third of the
third.
way to that 12%. I'm happy to answer any other clarifications you might have.
Thank you.
Thank you.
Yeah, this was in the previous land development code and the current land development code and the changes. Totally over ground floor.
Yeah, I don't know how we can just eliminate the requirement. I think they'd have to have some come up with some kind of, percentage or something that they want to vary from it. I don't see how we could just eliminate the requirement. I mean, these internal sort of mixed-use developments, it's not like your typical strip mall, running along the streets. You're trying to obviously buffer a lot of stuff. The buildings and everything kind of becomes internal. And, it's the combination of everything in there. So it's kind of hard to apply that sort of standard, those standard landscape requirements to a project like this. To me, it's kind of hard to do.
It would be easier on a strip center or a big box store where people aren't going to be utilizing the sidewalk spaces. You guys think?
There was like a percentage of what would be required, or there was I'm trying to think of the right words, but a real request of, instead of 12%, we're going to do 8%, or...
Yeah, that's what I was saying. We don't really have anything. We're just talking about eliminating the requirement, essentially. We're giving a variance to the entire requirement, which I'm not sure. I don't know if I feel comfortable doing that, but.
No,
if there was a request for a certain percentage or something like that, then maybe that's something we could entertain, but.
Well, I mean, that's always an option to ask them to come back with a redraw and maybe a percentage variance request from the 12% required.
Yeah.
It could be a combination of fixed pots and plantings, fixed planters and plantings.
I would also like to require permanent anchoring.
Why what? Sorry.
Permanent anchoring.
Fixed planners, so
Fixed
it wouldn't be,
planners,
yeah.
I'd like to have that, in writing in the proposal as well.
Yeah, I mean, we'd have to specify fixed planters that can't be just moved around.
I mean, that's within our purview to say, can you come back and give us a percentage of variance, and it's going to be made up, the foundation plantings will be made up of fixed plantings and fixed planters.
Yeah, I mean, do you hear what the chairman's saying? He would like to know if you would like to bring this proposal back with some kind of fixed variance to the standards instead of just a blanket, variance from the entire requirement.
Instead of saying 12%, we can do 6%, we can do 8%, we can do.
You want to go back and study it and see really what will make your project work the way you think you want it to be, and then it's a specific variance, not just we're just eliminating the requirement.
I mean, as far as, I think we could do that and look at establishing a percentage there. I do want to be clear when we're saying there's raised planters. We are considering these pots, which, I mean, yes, they're sitting on there. They're not necessarily a raised planter. If we're good with that and calculating the square footage or area to that, I think we can.
Yeah, good evening, Mr. Chairman. Alan McMahon with the Beach Company. We're partners with the Swain and Associates on this project as developers. Appreciate that, y'all's consideration. We're open to that. One thing I would say in terms of the planters, I think we're not thinking of just a 6-inch terracotta pot. We're talking about significant planters that would not be moved. We'd get a violation, I guess, perhaps if we did move them. But I think we can probably slice it different ways. We can look at that. We've studied stormwater to make sure, in terms of stormwater, McKim and Creed has studied that to make sure that we're still in compliance in regard to those standards. So certainly our preference, and one of the reasons we brought on CI Design, is they've got a history of doing a great job with this kind of thing. North Hills is an example in Raleigh. We trust them on this. So certainly our preference was to go the planted pot route. They've looked at specific locations and designed according to that. We think that's the best thing. And really, we're looking at this not just for this, we're not here asking for this for our enjoyment. It's for the enjoyment of the community. We think this is going to be a great public space. We've got the plaza areas, we've got a flush curb. We're looking forward to events out there, to families gathering, to folks eating and dining. So we're trying to create a great community experience, and that's the reason that we suggested this. That's our preference. If y'all want us to look at a different route, we're happy to do that as well. Thank you.
And I think you also have to look at it as the fact that a variance has to meet the 4 findings of fact where we're held to that. I think it's a better idea, and I wish that was what was allowed to happen, but that's not our decision. So I think if you look, because the challenge of this way the space is urban, where you introduce those things to show how you're complying with the space to add the benefit, but also the fact that you're tied to what you got. So these probably are a better solution down the road. So not necessarily because it's, it has to, we also have to be able to justify these 4, and it would be hard to do it right now.
Yeah, and I think if you can, bring back examples of what you're proposing as far as the planters, obviously we hear the city's concerns that they could be moved, and and they can't be monitoring these kind of things all the time. So you could be a violation, and they may not know about it for long periods of time. So the city doesn't have enough time in their daily schedule to go around and be monitoring what everybody's doing. So if you come back with a proposal on what you think a workable solution is, then we'll take a look at it.
I think fixed plantings and fixed planters, and so we can do these fixed pots, planters, fixed in nature, and plantings, and, we're not gonna meet the 12% requirement. We need a variance of 4% to get to 8%, or we need a variance of 5% to get to 7%, whatever that is, so we've got a specific to deal with. And we do need to address the city's concerns that they be permanent planters and permanent plantings.
I think we're comfortable with that. Obviously, the picture that we have up doesn't have the scale of pot there. It has more the intent of how we're trying to create those edges, not just with planting beds.
Right, I understand.
So if it's something where we need to look at it, come back and say we'd like a variance of 6% on that in lieu of providing potted plants or
Yeah.
potted plantings.
I understand, yeah.
I think we'd be amenable to that. That would be great.
Catherine, do we just continue this to October 20, or?
Yes, you can continue this to the October 20th meeting if you would like to give the applicant some time.
Will that give you adequate time to prepare if we move it out from today to October 20?
Yeah, that would be great.
Okay.
When would we need to have any additional information in?
Yeah, when would they have to get that in, though? I mean, we obviously want to give you enough time to really study it properly. So whether or not October may be too quick for you to turn it around, or?
So you all receive your packets, I believe for the October meeting, it'll be the Thursday prior to so a week in advance of the hearing. For staff to review that information and comment on it as part of the case summary, we would need to have it probably 2 weeks prior to the hearing. However, the applicant could bring information and present it, much like things have been presented to you this evening, actually at the hearing, if they miss the deadline to include it in the packet.
Okay.
No, that would be great. I mean, we can get some of that information ahead of time
And
to
then
you, and
then
otherwise we'll
enter it
bring
into
the rest.
evidence when you get here. Okay.
That would be great.
Well, in light of that, and thank you, I'd make a motion that we continue item 14, 1541 Eastwood Road to the October 20 Board of Adjustment meeting.
I'll second.
All in favor?
Aye.
Aye. Thank you. Okay, I've had a request for 2 minutes, gonna be long enough? We'll say 3-minute recess. Thank you.
I'm going to turn my mic off.
I'd like to call the Board of Adjustment meeting back to order. Item 15, 6120 Oleander Drive, variance to open space requirements for a mixed-use development in the CBCD district.
All right, thank you, and thanks for sticking around with us for a little longer than usual. On August 3rd, 2022, planning staff accepted an application for a variance to open space requirements for a property in the Community Business Conditional District pursuant to City Code Chapter 18, Land Development Code, Sections 18507 and 18664. On March 17th, 2015, City Council approved a conditional rezoning from O&I 1 Office and Institutional to CBCD Community Business Conditional District for a 25.78-acre mixed-use development and associated improvements. The approval included a multifamily conditional district area, a community business conditional district area, and 11.57 acres of open space. On June 18th, 2015, Summerwalk Phase 1 was released for construction. On March 2nd, 2022, an application was received by the Technical Review Committee for Summerwalk Phase 2 for a pre-construction or a pre-TRC consultation. Any change to the approved CBCD site plan would require the subject property to comply with the current Land Development Code. Land Development Code Section 18664 states development subject to open space set-aside standards shall provide the minimum amount of open space required for the zoning district, which shall be measured as a percentage of the total lot area. The property requires 20% of the total lot area to be dedicated as open space, or 43,260 square feet in this instance. When the development was originally approved in 2015, 11.57 acres of open space was established to meet the open space requirements. However, with the phasing of the project, the open space is no longer contiguous with the subject parcel. The applicant has requested a variance to Land Development Code Section 18664 open space set-aside standards to allow the existing and established 485,853 square feet of open space on a separate parcel to suffice for the required 43,260 square feet. The applicant states that more than 40% of the original development was set aside for open space when the project was approved in 2015. And this matter is set for hearing before the Board of Adjustment today, September 15th, 2022. This case is also subject to the 4 findings of fact, which I have put up on the screen for you. I ask that this case summary and all materials be presented into the record, and I am available for any questions, and the applicant and agent is here as well.
Thank you. Any questions for staff? Thank you.
Good evening, Mr. Chairman, members of the board. My name is Sam Frank. I represent the applicant. I'm with the law firm of Ward & Smith. Thank you for your endurance and patience tonight. I know it's been a long evening, and I'll do my best to be concise. Ask that the application that we submitted in the presentation that I handed to staff ahead of time be admitted into evidence, and thank Ms. Garman for her thorough analysis. Summerwalk's mixed-use development that was approved in the city in 2015, some things have happened since then. First, the first phase of the development has been completed, or materially completed. There's 123 homes that have been developed in the center section of that property. I'll point to that on the screen when I have it up there. Second, we've significantly changed our land development code, as you all are well aware, over the last 2 years, significant changes to the code. And third, there's been a meaningful evolution in the needs of the community. Those 7 years included 2 years of pandemic time and significant shift in the real estate market and the needs of our citizens. The original plan for the second phase of this development contemplated 80,000 square feet of office space. In lieu of that office space, the owner of the land today would prefer, here's the original approved site plan. I don't have a pointer, but the area to the right side of your screen that appears darkest is the section where those office buildings are located. Developer planned something more mixed use for that phase 2 area. There is substantial open space included in the total development. As Ms. Garman alluded to, that totals about 11.57 acres. The middle section, the phase 1 that has been developed, required just over 7 acres. The existing zoning approval does not include any of the open space for the total development on phase 2, It includes an excess of some 3.5 acres more open space than is required. So, why are we here at all? Why am I belaboring your time at the end of a long meeting? We need a variance because the way that the code has changed, if we change the site plan and the conditional zoning approval for Phase 2, we must comply with the current open space standards, which require continuity. So if we go back with a revision to the site plan just for the Phase 2 portion of the project, which of course is the logical thing to do here, it looks like an independent project, even though it is not. So for those reasons, we ask that you find that there wasn't a necessary hardship. Strict application of the code here without any acknowledgement of the open space that's already been established would result in an unnecessary hardship. The conditions are unique. It's the sequencing of the phasing of development of this project that led to this consequence, and of course the interim change to the code while that sequencing was occurring. The hardship arises out of changes to the code and a significant change to the market during the course of the build-out of the development, both factors that are completely beyond the applicant's control. And of course, at the end of the day, if you support what we are asking you to do, the total development will include more open space than was required under the prior code or than would be required under the current code for the total development. And therefore, the thing is consistent with the spirit and intent of the code. This is exactly the kind of formality over substance scenario that this board is empowered to correct. We respectfully request that you grant a variance from the open space requirement for the Phase 2 of this development, based on the fact that the open space to support Phase 2 is already established within the land included in the total plan of development for Summer Walk. A brief word about what this is not. We are not asking you to approve a new site plan for Phase 2. We're not asking you to do anything that would impact the zoning with regard to, really the zoning with regard to the total project, and certainly not with regard to Phase 1 that's been developed or the open space tract that has been established. This is not a rezoning. It is a nuanced and specific request for a variance of an aspect of the code that will allow us to adapt Phase 2 to match current needs and market conditions for the community. Mr. Chairman, I respectfully ask for the opportunity to speak in rebuttal after the public hearing.
Absolutely.
Thank you, sir. Appreciate your consideration.
Any questions for the applicant? Okay. Thank you.
Thank you.
I'll open up the public hearing. Is there anyone here to speak in favor of or opposed to the proposed zoning request?
Good evening. I'm John Brosnan, 2009 Cane Island Place. I also own another property in the development at 3907 Malabar Run. Here in opposition, as most of my neighbors back there are as well. I'd like to point a couple things, and I'd add this into evidence. This is a part of our HOA agreement, and it does show in there how we have 3 HOAs. There's a master HOA, there's the towns, which for the townhouses HOA, and there's the cottages HOA. And then over here it talks about the commercial property, one, and it doesn't talk about any multi-family homes. So this gentleman just talked about the spirit, the intent. I'd like for you to go back to the spirit of the intent. I know this isn't a rezoning issue here today, but what we're facing today is the very first domino that would fall and begin to cascade down the line. If you grant this space variance, you're essentially saying what's happened, the plan that was approved back in March of 2015 really doesn't matter now. We're just going to give this guy the opportunity. The hardship that he spoke of, if anything, the hardships have been put on by Mr. Penn himself in choosing to change his plans from what he initially decided. The values, as everybody knows, from home values have gone through the roof, and they've seen just down the road a little bit. There's some on Oleander, some apartment buildings have just gone up, and I think Mr. Penn sees the ability to capitalize and put as many homes, townhomes, apartment buildings, condos, what have you, per square foot, with no regard for the traffic situation that this would do for our area. The neighbors would have to then go through the current neighborhoods that we have, turn on either direction on Greenville Loop Road. If they're trying to go to Oleander, they'll have to turn left. That's already a pretty good bottleneck, but if you add another 200 apartments to this mix, it's going to be quite a mess. So things that I'd like to point out to you that was this gentleman's talking about the hardship. Any hardship that's imposed would be from the developer himself. To insinuate that either the pandemic or current market conditions have made a hardship for this developer is completely false. Everything from day one has been Mr. Penton's plan. He has yet to meet with any of the boards. We're supposed to have members of the boards that are able to meet with the master HOA. In the entirety of the existence of the HOAs, he's yet to meet with any of them. So there's been no cooperation, and I'm certain that wouldn't be in the future. And so I would like to ask you, plead with you, to deny any request for this space variance, and I'm sure I have some neighbors here that might add the same. Any questions for me?
Any questions?
Mr. Chairman, I have a packet that was prepared by Mr. Brosnan. We've got copies for the board, should you like to review them.
Here's a letter that I mailed in, but I was told, same letter, you got it? Okay, great. And this is the same thing that he just put up on the board. I'm sure you have a copy of that. Thank you.
Hey, everybody. My name is Elizabeth Caden. I'm also a property owner at 3660 Watch Hill Way in Wilmington, part of the Summer Walk 1 phase. I understand that this is a variance meeting, not a rezoning meeting, so I'm not going to speak to any plans that may or may not be forthcoming that are in the Technical Review Committee at this time. But I did want to speak to the 4 points that would position this for a variance. So the first one is, I do not believe that unnecessary hardship exists from strict application of the regulations of the LDC. So this property is currently zoned as a commercial business, and there's no sufficient example that they would not be able to put a commercial business building or development in that area. We haven't been given that. And I would like to speak to the last case we just heard, where we heard that there was a request for variance, and right now we're having that same thing where there's no way to tell what that variance will in fact turn out to be. So if it's granted, it could be 100% cement. We don't know that, and I think that that shouldn't be just granted outright. It was also the choice. So speaking to the hardship does result from an action taken by the applicant or property owner. That applicant chose to sell the property as is, and that is what resulted in the discontinuity of the property we're discussing today. So if he chose to not do that, we wouldn't be having this conversation, and he wouldn't be having to go through this variance request. To be fair, and the hardship does also not come from conditions peculiar to the site, which are not common to the neighborhood and general public. So COVID hit everybody really hard. The pandemic certainly hit, I think, probably everybody in this room somehow, some way, and the market conditions did as well. So that is not something that's uncommon to anybody in the general public or in the neighborhood. And then finally, the requested variance is not consistent with the intent of the LDC such that public safety is secured and substantial justice is achieved. So one, what's not shown here is that this actually borders a fire station, and any variance that happens may or may not impact the public safety of that area. Of course, again, we're not talking about rezoning, so we don't know what's going to be done with that land, but as it stands, that is a fire station, and anything that is done on that land may or may not impact their ability to respond to emergency requests. Not to mention, that area is on a heavily trafficked road, and as it stands today, there is no safe crossing across Oleander or across Greenville Loop Road, so those people or that space there does have a question of public safety, no matter what you do with it. And then finally, I think you had one more point. Sorry.
You made it.
Okay, sorry.
It's okay. She made the point that I was going to add on to regarding Greenville Loop and Oleander being literally one of the most dangerous intersections in Wilmington. I'm sorry.
Could you state your name and address,
Sure,
please?
it's Christy DeFelice. I live at 3917 Malabar Run. another neighbor of Summer Walk community. And just to add on to what she said, the matter of public safety, I think, is a great concern for the community. It's already a very tight space for traffic, parking, and along, same lines with the fire station being right there. So adding this, or adding the option to add this, because again, I know it's not technically a zoning meeting, but allowing that flexibility is a great concern for the community. Thank you.
Thank you.
Thank you.
Sorry, are there any questions for any of us?
Any questions?
Can I have you state your name one more time?
Elizabeth Kane.
Elizabeth Kane, thank you.
Thank you.
Thank you.
Mr. Chairman, similarly, Ms. Kane prepared a written document that it just spells out the things that she just presented to you, if the board would like a copy of that as well.
You want a copy? Yes, please.
Chairman, I'd like to point out that if we go past about 15 more minutes, I'll have to do a brief pause to switch recordings so that we get everything.
Okay, thank you.
Okay, so hello, I'm David Artrip. I live at 6018 Richard Bradley Drive in the Summerwalk Townhomes. I just wanted to, I guess, follow up to the point that the council had made about the planning and that this is nuanced. This isn't nuanced. This isn't outside their control. They're the ones that developed all three phases of this. So to me, it appears to be, poor planning. And even the open spaces, if you look at that, it's actually drainage. We moved here, I bought in 2017, and 5 months later, a hurricane hit. And, thank goodness those spaces were intact, because that's where all the runoff went. If we change anything, I mean, even down to one of the spaces that's not even put on there, but in phase 2, there's another, I don't know if it's a detention pond that's not even shown there. Any change to that is going to flood the area. So this is something that's already been stressed at what it is. And then I know some of the other neighbors had spoken to the roads. This is a choke point. Anyone that tries to turn left on Greenville Loop in between 4 o'clock and 6 o'clock, on a weekday, it's already stressed. Because there's only two ways to really kind of get into the peninsula. It's there, and I'm not certain the other road by the park. But what we would be doing at that point is just overdeveloping a space that doesn't fit. And then the other thing I wanted to mention that the council had said was that the market's changed the need for housing. That could be true, but it doesn't mean it has to be there. You can't be all things to all people, and if you want to build an apartment complex or something different, there's other spaces within the city to build. It just doesn't have to be there. We may want a soccer stadium as well. It wouldn't fit there. So that's just kind of my, I guess, request to the group is just to consider what's there. Okay.
Thank you.
Thank you.
My name is Sam Lewis. I live at 113 Hidden Lake Lane. I thank you for the opportunity, Mr. Chairman, board members, to hear different points of view. I actually live in a subdivision literally just across Greenville Loop Road from this development. I was at the City Council meeting where the 2015 approval for the conditional use permits were granted. A couple of the City Council members during that meeting cited the road improvements and drainage as reasons to support that development. I can tell you firsthand that the drainage issue is still a significant concern, but not just in this neighborhood. The open space area there, I think, is supposed to have a retention pond there. And I think it actually, even on this drawing, shows there's supposed to be some walking paths and what have you there, sort of a recreational area. I'm not sure that actually manifested itself. But what I can tell you is that when you have a hard rain down Richard Bradley Drive, the extension that goes up into Summerwalk now, it is at an elevation. There were dozens and dozens of truckloads of dirt brought in when summer rest was built, and the elevation is significantly higher than our entire neighborhood, which coincidentally sits on a similar sized plot of land. We have 20 homes. They have 120. That water runs like a torrent right down the street and right down our part of the street and down into a drain going into what used to be a small creek, which is now floods regularly over its banks because of the drainage. That drainage is also problematic because there was a culvert cut as a function of this project to direct more of the drainage into the creek, which goes into the body of water behind our development called Hidden Lake. Okay. Hidden Lake is a man-made lake. Okay, it actually is sort of straddles the property between our subdivision and a cemetery right behind our subdivision. It is actually the result of a road bed, elevated road bed that was built through the cemetery when they built the cemetery for the road, and it is connected to the marsh. So all of this drainage goes into the marsh, which goes into the waterway, which goes on in there. It is a problem now. When you talk about the intent of the open space here, I'm not sure what the intent was, and I'm not sure what the intent is supposed to be of open space in a development like this. But I would assume adequate drainage would be part of it. The other issues related to traffic, you take your life in your hands when you turn out of my neighborhood now to go anywhere. The modest additions to the roadways basically just created another lane, another queue lane. And I think it's pretty common knowledge that in the city of Wilmington right now, the infrastructure just cannot handle the load as it exists currently. This variance paves the way for what was called a transitional density development back in 2015 into one that is incredibly transformational in my neighborhood. So I respectfully ask that you consider not granting this variance. Thank you.
Thank you.
My name's Nick Mitchell. I'm at 3925 Malabar Run. I'm on the HOA with Christie. Pitton from the get-go has been pretty hostile or non-communicative with us about any issues or needs, whether they be drainage or otherwise, with our development. Coming off of that stoplight over that area, it already drains now, and the drainage area that's not pictured there in that picture in the blue sectioned area overflows into the road during normal storms. Covering or utilizing that additionally would probably flood it even more, especially during a hurricane. The rear area that's pictured green is an unmaintained area that he has kind of dumped stuff, has random piles of riffraff and water, but it doesn't actually work super well. He's actually, I think, in violation with the city right now for the retention ponds that are behind some of our units and other areas. So in general, I think that he hasn't really followed or tried to follow. He's just tried to skirt what his requirements are, and I think this is another example of that. Because anything that he has said in the past about what our neighborhood or our community was going to be developed as has not come to fruition, and he seems to change it up. So, thank you.
Thank you. Anyone's here to speak? Rebuttal?
Thank you, Mr. Chairman, and thank you all. Appreciate the comments from those who chose to deliver them. It's clear that there's opportunity here when we get to the zoning phase of this project to engage with the community and hear what the neighbors have to say, because it's obvious that there's some opinions about those details. just to be clear, the current zoning allows 80,000 square feet of office space and no open space on Phase 2. The reason we're having this conversation is because as things have evolved over the last 7 years, fewer and fewer people depend on office space. And therefore, it is a less logical and community beneficial use of that land. And certainly, part of the impact I just described was influenced by the pandemic, and that's why the reference to the pandemic, both in my presentation and the application, I wanted to be abundantly clear about why that led to the condition that necessitates this today. This is not a zoning hearing. We are not asking for anything that has any impact on the established requirement to put open space where you see green on the screen. This is solely a request that you allow us to use the open space that's already been established to support Phase 2, to support the part that's shown in purple on the screen. For what it's worth, even though this is not a zoning hearing, the vision for the development of Phase 2 is something less intense than what is currently permitted under the current zoning. We envision something that's mixed use, something that has less impervious surface than what is currently drawn and approved. I can go back to that. And I know this is small, it's awfully hard to see, but you can imagine large office buildings with significant parking as is required for them. It's a very commercial feel to the current approved zoning for the site. Thank you. All of the conversation about traffic impact and the like is certainly valid and important, and all of that comes at the next step. That's part of the conversation about what are we going to propose and how much less intense, how much less traffic is that going to introduce into Greenville Loop and Oleander Drive than what's currently permitted under the current zoning. I guess, although it's obvious that it's not relevant to your specific consideration today, and my client's not here today to stand up for himself, so I'm going to briefly do that and say that I appreciate what members of the community have said about concerns about their interaction with the developer. We'll look for opportunities to improve that going forward, but the character of the landowner is not really the question before you today, and landowner's not on trial. This is about whether or not it makes sense for the city to grant a variance because those 4 findings have been established. That's the extent of what I want to say in rebuttal, though I'm also eager to answer any questions that you may have of us.
Any questions for the applicant?
By going with the
Thank you.
with asking for the variance and down the road, if there was a rezoning, wouldn't the variance go away? Wouldn't follow, wouldn't the variance be tied to the way it's currently zoned? And if you came back and rezoned it, what is the impact of that variance? That would probably be a question for a city attorney, but I was just curious on, talking about the changing, you would have to, I mean, it's not a zoning, but won't you have to come back to?
I'm glad to explain that as I understand it, and then also defer to Ms. Huffman to answer if she's inclined to. When we go back to propose, and that's the plan, I want to be very transparent about that. When we go back to propose a change to the zoning, what we're talking about is changing the existing conditional zoning to a modification of the conditional zoning for Phase 2. When we do that, if we did not have this variance, we would be proposing something that was inconsistent with the new code, because the open space would not be incorporated into Phase 2, just like it isn't now. But because it's a look anew at just a third of, or a small portion of the project, the city has to review just what we've proposed to them. Open space is not contiguous. Your current code no longer allows for that possibility, hence the need for the variance today.
I completely agree, and that was very well presented.
Thank you, ma'am.
I thought it would be good that it was actually talked about.
I had to ask the same question of my client when he first told me we needed a variance, and I understand exactly
Okay,
where you're
that's
coming
where, I just wanted to get clear. All right, thank you.
Any further questions? Thank you.
Thank you.
Open it up for board discussion.
I can obviously see the perspective of both parties here. I mean, I would like to have more assurances, and I think the residents there would like to have more assurances as to what the proposal is for that property before, granting any kind of a variance. I'd like to kind of see, what impact a variance would be on a project like this. I'd like to see what kind of variance is necessary before granting a variance like this. To me, at this point, when you start redeveloping that and you're changing the type of uses, it does change the complexion of this development. I'm not so sure that, depending on what they do there, there may need to be some additional open space in that portion of the property. So I would be reluctant to support, a variance to the zoning until we saw a little bit more about what they were proposing there. Right now, it's just a blank slate.
Right. Thoughts?
I tend to agree with Mark on that, just because we don't know what's going to go there, and it could end up being apartment on top of apartment on top of apartment with no space there. So I'm not opposed to the variance. I would just like to see what's going to go there and how that's going to impact the residents in that area.
I'm not necessarily opposed to the variance, but again, I too would like to see a little more clarification on what is going to be proposed for Phase 2, so we can see how the open space is affected, how it affects the overall plan, because it's granting the variance with a blank slate is a little concerning.
Is it possible to add to that? So we
Aren't you close?
have actually
I
seen.
think we closed the public
We've
hearing.
closed the public
Close
hearing,
it,
I'm sorry.
close it. Okay.
Mr. Chair, I might be speaking out of turn, but would applicant consider granting a variance that's contingent upon successful rezoning? It's just an idea. That way, I don't think that you all are in a position to know the next step. You're going to have to go through the process to get through city council, correct? And then it may keep you from having to come back.
We certainly do have a chicken and an egg dilemma.
Yeah.
So all of the details that we're talking about have to go, we have to have a community meeting, we'll have several. We have to go before planning board, we have to go before the city council. And so that is steps yet to come based on a design that's yet to be established, because the door isn't open for us to pursue those alternatives until we know your thoughts about this discrete question about treatment of the non-contiguous open space. And so the suggestion that you make is absolutely something that would be acceptable to the applicant. We know very well that nothing happens different from what's already approved here unless and until a rezoning is successful.
And my concern is that when you get through that process, once they get to the city council level, city council is going to want to know what the Board of Adjustment will do with that variance request. So like Mr. Frank said, this is sort of a chicken and the egg situation that we're in. That's just a thought for you all to consider during your deliberations.
And I'm going to open up the public hearing. Sir, if you'd like to speak, I'd like you to come forward and speak.
Madam, just as a matter of process, in full disclosure,
the city staff did advise the applicant that typically before such things get in front of city council wants to know that any other reviews that need to take place, like, you know, getting a certificate of appropriateness or getting a variance if necessary for the proposed project, they want to make sure that that has already been completed before they consider the item.
Madam Clerk, are we still okay with our recording? We've hit 6:01. Okay.
Go ahead, sir.
So just to add
If you could state your name and address again, I'm sorry.
Nicholas Mitchell, 3925 Malabar Run. To just add to what's already been said, we do have some designs and some idea of what he's planning for this location, and it's supposed to be possibly a 5-story apartment complex with tons of parking, which will again cover a huge portion of that entire area, which again, like we've addressed about the whole water issue of many, would contribute to that greatly. So there, we're not really guessing what he's trying to do. We've seen designs, we have some printouts of the design as well. It's supposed to be very tall buildings, no trees bordering between our units and this large apartment complex with solid concrete behind all of our units. So it's just gonna totally change the space itself. But that's all, thanks.
Thank you.
Oh, Catherine, would you mind going back a couple slides for me? So what the current zoning contemplates is large buildings, asphalt, and what was just described. If you open the door to us approaching the city to request something different, we will inevitably have to redesign with the considerations of the community, the comments of staff, and the like in mind. There are some conceptual ideas that we have on the table for what we think should go there, but I feel like it'd be irresponsible and premature for me to present those concepts to you now because they are just that. We haven't had an opportunity to discuss with staff what we have in mind. We haven't had an opportunity to hear the engagement from the neighbors. And so anything that I would say to you now about what we think we might develop is, again, is premature. From the applicant's perspective, we are open-minded to the suggestion that Ms. Huffman made. I'm also open-minded if it's helpful to share more information as best I can about the potential uses for the property. But I would encourage you or ask you to focus solely on the question that's been asked, which is whatever is ultimately approved for this property ought to be able to rely on the open space that has already been established. And that is the singular question that we have asked you to consider today. Thank you. I appreciate your time.
Thank you.
I'm sorry, what was the potential substitute process?
I was just suggesting that if you wanted to make the variance, the granting of the variance contingent upon the applicant successfully getting through the remaining rezoning process and going through city council. So that way, if they were not successful in rezoning, the variance would be null and void. So if they could not change their plan, and Mr. Frank, please correct me if I use the wrong terminology, but if city council decides, no, we're not going to allow you to change your site plan for phase 2, then they would still then have to comply with the current, no, you wouldn't have to comply with the current land development code, would you? I'm talking out loud now. I'm sorry, I'm thinking out loud. So if you went through the process at city council and city council says, no, we're not going to allow this rezoning, the variance would be null and void. And if you try to change the plan in any way from there on out, you would still have to comply with the current land development code. Or otherwise, just build what was originally intended in your conditional district rezoning, correct?
I agree with everything you just said. The only other possibility is to propose a rezone for the entirety, for everything that's green, tan, and blue on the screen. We've deliberately not pursued that because what's green and tan on the screen is now owned by other people. And there isn't any reason to ask people who've acquired land or an owner's association that's acquired land to participate in such a thing. So Ms. Huffman's conclusion is correct. If your objective is to make sure that the variance that you grant today does no harm, if the city council doesn't like our plan, then the procedural option that Ms. Huffman has described achieves that and is acceptable to us as the applicant.
Yes.
Not just to have the last word, but every time something comes up, he comes back, and it's really not helping our cause. It goes back to the dominoes. John Brosnan, 2009 Cane Island. If you give them the approval today, it almost rubber stamps the next step for the rezoning. Maybe not, I haven't been to a rezoning deal, but it starts with you gentlemen to say, hey, maybe we don't need to give him the ability to have more space. He could have done this years ago. He could have had approval for it years ago, and it's only now that he sees that he could capitalize. So I just, again, would ask you to take into consideration the current land development code and stand by that. That's what I'd ask, and deny the space variance request. Thank you.
Thank you.
I don't think that's exactly accurate. That's not how I would characterize the rezoning process. City council is not going to look to, city council is going to consider many, many things before they grant a rezoning, and one of the many things will be this variance request. Like Mr. Frank said, they're going to have to go through community meetings, Planning Commission, TRC as well.
Yes.
Many, many steps before you all, so you're not necessarily the threshold. You're just one of many steps.
And to piggyback on Ms. Huffman's comment, staff would make comments in the case summary relative to this variance and make it very clear in that the variance that was granted was only with regard to the open space requirement, and provide an explanation of what the board's decision was and the basis for that. Not necessarily, it would not go into the use of the property to the along Oleander Drive, because that isn't within your purview this evening.
I think there's still, in my mind, and it's probably the residents' mind, is that, by granting this variance, they really don't have much of a say in whether there's going to be, some open space in that future development. We're pretty much giving that away. And I know that it has to go through, planning and city council to, I don't even know if it goes through planning anymore, city council at least, to come up with a new plan for this. But I'm just not comfortable with just granting the blanket variance. I'd prefer to see some effort to kind of give us an idea what they're proposing, and are there ways to create some open space in those areas? It's just not, I know the current plan is they don't have any there, but, and, market forces change. I mean, that's just life. Office space, maybe a dinosaur, I don't know. Maybe people are going to go back to offices, but, that use is probably not, not something that's is in demand anymore, but certainly residential around here it is. But to me, we're getting overdeveloped with residential. But I'm just not comfortable with the granting of a blanket variance on this, without any kind of site plan or something to go by.
agree with Mark. I'm not comfortable with a blanket variance for this property as they're laying it out to be.
Okay.
Yeah, I mean, I agree with not knowing where it's going to be, and most likely it probably could impact where it will actually be better for the area by going forward with that. But the unknown, and a lot of it's probably just the relationship from maybe the personality and the development side that has skewed anyone to listen to the possibility of a change, which we can't dictate that. But you could like try to move forward with coming with something that gives people a little bit more of an idea what's going on. And you've had the people that are here, like it's not what you want to hear, but you could connect with the people that are here that opposed it, because they're the ones that give the hesitation to it, and rightfully so. So maybe you open this, like all we're doing is continuing things so we have 17 items for our next meeting. But that might be an option of trying to get a little bit more uniformity too, because the rush, I mean, you still have to go through a major process, and I know that City Council's not going to want to send it back saying, we approve everything, go get a variance for after that, because I get where you have to go with procedurally. But just a thought, because right now you're hearing the negative side of it.
Yes.
We're just all out there.
So the intent and the way that we shaped this up was to try to keep it simple so that you were only talking about continuity of open space. And I respect that in the greater scheme of things, the question is more complicated than that. If you are willing, and I realize I'm asking something of you to put something else on a calendar that's likely to be busy again next month. But if you're willing to grant us some time to work up a concept that we can share with you, that wouldn't be a site plan, it wouldn't be a zoning approval, but it would give you some better idea of where we're headed. If that would help you answer the question we've asked you to answer, we're certainly willing to do it and agreeable to continuing for that purpose.
As part of that, would you agree to, before you come back to us, to meet with the residents that are, have a concern with this, to try and answer their questions and try to help them understand, what you're proposing and how you think it's going to be a better fit for the overall community?
Absolutely. I'll say candidly.
Whether or not you can do this by the October meeting, I don't.
Well, and my name and phone number are on that application, and I haven't heard from any of the folks who chose to speak today, and wasn't entirely, a little bit surprised that there was that opposition. And so I would be grateful for the opportunity to meet with the people who've spoken here today to answer your question.
Yeah, so, I mean, I think it's, it makes sense, considering the opposition to try and, at least help them understand, what you're proposing to do and how that might be a better proposal than what is currently proposed.
I couldn't agree more. There was a lot of misunderstanding reflected in the comments.
So I guess the question is, do you have enough time between now and October to do that, or do you need us to do November?
I don't know, and I don't have my client in the room with me to ask. May I ask that you continue it to October, and I promise you within the next 3 business days that I'll communicate with staff if for some reason that's not enough time for us to get it done.
Yeah, we could push it off to November if it's,
Yeah, and
if you don't have enough
I
time.
don't think anyone up here is opposed to the variance request. Our opposition is to the variance request with the unknown of what's going up there and how it's going to impact everything. I mean, it's a blank slate that we have a hard time granting.
Well, and just to be absolutely candid and clear, if you approve this variance today, we have no zoning approval to do anything other than what we already have approval to do.
Right, I understand.
We have to go through TRC, we have to go through planning board, we have to satisfy staff, and most importantly, we have to satisfy the city council. And so the details of what ultimately is built there will be very, very well considered and vetted by others.
I understand. But I think we would feel better with a little bit of an idea, and I
For
think
context.
I think the residents would feel better with a little bit of an idea. So,
Thank you.
if you're not opposed, we'll continue to October 20.
I appreciate that. Thank you.
Chairman Moore, we have 13 items on that agenda, and we've been informed already that Member Monroe will not be available for that meeting, if that changes the scheduling at all for the applicant.
But we have 5.
Potentially, we haven't pulled the board yet.
Let's simplify it and just ask you to continue to November if you're willing.
Okay.
Yeah, I think that makes more sense.
Okay. We have a request to continue item 156120 Oleander Drive to the November 17 board meeting. Do we have a second?
I'll second.
All in favor?
Aye.
Opposed?
Aye.
Continue to the 17th. Thank you, and thank you.
I know. Is it on the way?
I'm sorry. If there's no further meeting, no further business before the Board of Adjustment, the meeting stands adjourned.